But Dee and I have been watching this whole thing since the beginning, and we thought we would just go live today and watch it with the channel surfers. If you care to join us, welcome. All right, now I got to find it. I know it's on SETV. What we're looking at today, we're going to go to the South Carolina Supreme Court in Columbia, South Carolina. I've got my Columbia Bar 2012 bar convention. Ooh, that was a while ago. Columbia, famously hot. Got my Columbia drink. All right, let's see. I'm prepared for the occasion, except I do not have the live feed up yet. We're working on it. Let's see. SETV. I think this is it. Okay, let me change. Well, no, I might need to do it that way. All right, guys, just bear with me. I am pulling up Murdaugh appeal. Here we go. SETV. All right. Live. Found it. All right, here we go. All right, we're starting with
I sat
Dick Harpootlian.
right about there. Chief Justice Woodrow Lewis had us stand, hold our hands up to be sworn in as new members of the bar. All of us could fit in this room. That's
Yeah,
how long
we
ago
did it
that
at the
was.
Coliseum. It was a lot
But
bigger
one of the
class.
things that impressed me that day was the oath. And part of that oath was that we swore to uphold the Constitution.
Absolutely.
And as I stand here today, I'm honored to be arguing about how to interpret that Constitution.
Ooh, I'm so
the Sixth
excited.
Amendment
D
specifically.
Constitutional law.
And in my
I don't know
my
much
opinion,
about it.
I would suggest the Sixth Amendment may be the most important amendment, because the First Amendment, which gives
Turn
you
your
the right
mic
to
up a
speak
little. I
without
can't hear
government
you.
interference, or the Second Amendment, which
that
gives you the
better?
right to carry a weapon or have a
I'll
weapon
turn
without
it
government
down a little.
interference, mean nothing without the right to a fair trial and a fair jury. So this matter we're discussing this morning, a fair trial, a jury not poisoned by outside influences,
Mm-hmm.
I would submit to you is 51 years
no.
ago, as I stood there, I did not
Court
realize
reporter.
what I was swearing to do, but I do today. And that is to
That was a
defend
really
Alec Murdaugh's
interesting
right to a fair trial.
case when we saw Becky Hill
And I've got to
go
admit,
in
in
front
the
of
51 years
former
since
Supreme
then, I've
Court
never
Chief
seen a
Justice Toll.
factual
She's actually
pattern
the
like
Chief Justice
this,
that swore me in.
where the clerk of court,
But she
where
even
the
said
clerk
at
of
the end
court
of it
sets out to influence the
Becky
verdict,
behaved
to get a guilty
inappropriately.
verdict for financial
Mhm.
gain. Now, I do want to go to the record fairly quickly and summarize it so that there's no
That's going to be one
misunderstanding.
of their basis.
Rhonda
for appeal
McElveen, who's the
here.
Barnwell clerk of court, was asked by Becky Hill,
Some of it's going to
Colleton
have to
clerk of
do with
court, to
whether or not
assist her
evidence should have been
during the Murdaugh
admitted.
trial.
What a good trial attorney does is
She testified under oath that she was told by Ms. Hill that she, being Ms. Hill, might write a book
the
because she
ground for
needed a
appeal.
lake house.
They make sure that
A
they have
guilty verdict would sell
objections
more books. That was
that-
said
that
before
can be appealed
December
on.
of
Make sure
22.
you're
We didn't pick
there
a jury until January of 23.
setting the record.
The best way to
for
sell
appeal.
books was a guilty
That's one
verdict.
of the things that
A
makes,
guilty
like,
verdict would be
Harpootlian a
better
great
for the
attorney.
sale of
There are
books.
a lot of grounds that they had. The briefs.
So
were
she
like
explained she had a
250
financial incentive
I
for a
don't know.
guilty verdict. She also made comments to her like, don't be fooled by the evidence presented by Mr. Murdaugh's lawyer. Watch him closely. Just before he testifies, look at his actions, look at his movements. Identical to the statements that I'm going to read you in just a moment by the jurors as they were
What you
questioned.
see here is
Juror
Parker
P,
Leland
on the
is
day Mr.
arguing in
Murdaugh was
front
taking
of
the stand,
Supreme
Becky Hill made a
Court
comment.
panel
Watch
of
his body
judges.
language.
So they're
Juror
all sitting
X,
on a bench in
prior to
front of
Mr.
him.
Murdaugh's
You
testimony,
get 20
Juror
minutes
X
to argue.
heard Becky
then they're
Hill
gonna
say
touch everything.
words to the effect of, looks
The
like the
judges can
defendant's going to
stop him and ask
testify.
him questions.
This is
Now,
an
at
important day.
point,
This is
the
an
judges have
epic
read
day.
all
It
of the
was, it's
briefs
rare for a defendant to
and
testify.
everything. So
Juror Z, watch his
they
actions,
know what's
watch him
coming. This
closely.
is a great opportunity for them to ask
In
questions.
addition to that, Juror Z said in an affidavit and affirmed in court that Ms. Hill told her not to be fooled by the evidence presented by Mr. Murdaugh's lawyers, attorneys, which she understood to mean Mr. Murdaugh would lie when he testified. And that Ms. Hill instructed the jury to watch him, Murdaugh, closely immediately
I like
before he
it.
testified, including look at his actions, look at his movements, which Juror Z understood to mean he was guilty. Alternate Juror 741. Before the defense put up their case, Ms. Hill told the jurors the defense is about to do their side. They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off. Hill told juror 741 Murdaugh was going to testify before he testified. That's what the jurors said under oath. That's what the clerk of court of Barnwell County said under oath. Judge Toll from the bench said at the conclusion of the hearing, asked the question, did Clerk of Court Hill make comments to any juror which expressed her opinion as to what the verdict would be? Ms. Hill denies doing so, and so the question becomes, her denial credible? Was her denial credible? I find the Clerk of Court is not completely credible as a witness. Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed it as early as November 22, long before the trial began. She denies that this is so, but I find that she stated to the Clerk of Court, Rhonda McElveen, and others her desire for a guilty verdict because it would sell books. She made comments about Murdaugh's demeanor as he testified. She made some of those comments before he testified to at least one and maybe more jurors. The Clerk of Court allowed public attention of the moment to overcome her duty.
Can we consider the egg juror's affidavit?
I'd like you to.
Well, in the record, of course, you mentioned during the hearing, she's across the street. Judge Toll said, no, she's not going to testify. She let the alternate juror testify for impeachment of Ms. Hill. That's what her stated reason for was during the hearing. What was the rationale for her not allowing the egg juror to testify?
I don't know. Because as you point out, if Juror 741 was to impeach Becky Hill's credibility, now.
So the egg juror, this is the one that was one of the original, I think, alternates. And then during the trial, that whole thing came up about maybe her ex-husband knowing something. And then it turned out that Becky Hill was sitting there like spreading rumors. And at the hearing that they had in front of Justice Toll for a new trial dealing with Becky Hill, what they're saying is they allowed that alternate juror to testify in order to impeach Becky Hill, in order to attack her credibility. So what the justice is asking here is, why didn't Justice Toll allow the egg juror? And Dick Harpootlian says, I don't know.
Now, of course, she was not a deliberating juror.
Well, neither was the alternate.
Correct.
Who did testify.
Correct.
So my question.
Okay, so neither of them were deliberating jurors. Neither of them had a role to play in the guilty verdict.
And remind me why she was called the egg juror. Was she bringing
Because she
eggs?
showed up with eggs. Yeah.
Okay, that's what I was thinking.
Showing up with her fresh eggs with her chickens. I love it.
Question is this, and I'm sure Mr. Waters will cover this. If the egg juror's testimony was just as theoretically impeaching as juror 70 or the alternate juror's
Double impeachment.
testimony, 741,
How does
why
this
wasn't
work?
the egg juror allowed to testify?
And I'm not sure that she stated a coherent reason other than she wasn't going to. Remember now,
But she said her affidavit is in the record, so we know what she
I think I
said,
know that
Ms.
attorney
Hill
at the time I
said,
graduated
and
law
we
school
now
with.
know what Ms. Hill said she didn't say.
yes.
So I take that to mean that it was considered. The egg juror's affidavit was considered by the court, and we can consider it.
In our defense, when you look at the record, remember, we were starting off with no one was going to examine anyone
Maybe
under Judge Toll's initial order. And then it was a moving target. Then it was going to be some that were going to be examined. We weren't going to be allowed to examine. Then we were allowed to examine. So it was an evolving process. If she in fact considered the egg lady's affidavit, she did not cite it in her order. Just as she did not cite Juror Z or 741's statements about do not be fooled, comments about how the attorneys are going to try
The
to
state
deceive you.
argues in its brief that Judge Toll, in making specific finding as to certain things jurors did say, was an implicit rejection of the other statements the jurors said Ms. Hill made. What's
I
your
would-
response to that?
Well, I would say that's wholly unsupported by the record. I mean,
I
a
don't
judge in an
think
order is going to
why
say what
that.
they considered, and they should say what they didn't consider and
I
why.
agree. I
Mhm.
agree with
This
that.
this
That needs
implicit,
to be laid out on the
implicitly,
record.
I mean, the statements by 741, by Juror Z, and by the egg lady, all had bearing on Clerk Hill's credibility, and what happened is critical. And let me say this also, even if you didn't have what they said, if a judge, as the jury came in on the day Mr. Murdaugh was going to testify, said, it's an important day, it's an epic day, you better watch how he testifies, and doesn't say that about any other witness, except
I
some sort of
agree.
charge at the end of the case, or maybe before, but specifically points that out.
Mr. Harpootlian, let me ask you this. Judge Toll placed the burden on your client to prove prejudice in this case. Does Green establish, in a case with external influence on a jury, a different standard and burden of proof than Rimmer and the Fourth Circuit jurisprudence?
No, it does not. It's consistent with Rimmer. All Green says
So
is,
going back
we're not going to go
to,
through this burden shifting or any of this until we determine whether the statement was inconsequential. I say inconsequential or consequential.
going back to that hearing with Becky Hill, Dick Harpootlian and Murdaugh's team, they were arguing the Fourth Circuit case. So South Carolina were part of the Fourth Circuit, but this is going to be the federal courts. We're talking about federal law versus state law. I practice in the Fourth Circuit. So she's asking, basically it was up to Murdaugh's team to show that there was prejudice. And she's asking about the difference between the Green case, which is the South Carolina case, and the federal Fourth Circuit case.
And if it is inconsequential, we're not going to go through this analysis. That's all it said. And I'd point out in Green, the process used by Judge Toll of calling all the witnesses.
So in Green, you basically have a test. If it's inconsequential, then you don't continue with the analysis. If what was said is consequential to the verdict, then you're going to continue with the test laid out in Green as to whether or not you get a new trial. Does that make sense?
I think so, at least for me.
So there is a hurdle you have to jump before you decide with the new trial. You have to decide if it's inconsequential or not. That's kind of hard to say, though. I mean, that's a psychological question. Like he said, if no other witnesses if their testimony wasn't made a big deal, if Becky Hill wasn't sitting there jumping up and down, oh, it's the coroner, which my friend Rebecca worked with a guy that stuck his arm under the armpits. She's like, he used to be my professor. I don't know why he's saying this. She really liked him. She's like, he's so
Mhm.
good. This doesn't make sense. But like if she wasn't making a big deal out of that, then psychologically, if it's like this guy's a liar, pay attention, that could influence you. Maybe you don't even realize it, but maybe that does tip you one way or the other.
Especially since it was just one witness that she said to watch. She wasn't
And
saying
it's
to
the
watch any of the other
defendant.
ones. Yeah.
And it was
True.
the defendant.
Up and ask him if it had any influence. Judge Hill, in a footnote in the Court of Appeals Green decision, points
That's a nice
out
move.
that
Citing the
606B,
judge that you're in front of.
he says it's not raised in this case, but, should we be asking jurors anything about verdicts? And that's another complicating factor with the process that Judge Toll used. So,
Well, that's an interesting point because Rule 606B says that you can't consider the effect of something on jurors because otherwise you're invading
yes, sir.
the thought processes of the jury. But how could the state rebut the presumption without doing that?
Well, I mean, I think very simply, all the other cases that you look at, if you look at like Parker versus Gladden,
How could the
where
defense
a
prove that
deputy says he's an evil fellow and, he's guilty,
without getting into
Right.
where
they say
jurors are thinking?
this, you can't rebut that. That's not
Exactly.
rebuttable. And so he gets a new trial.
But in Parker versus Gladden, they talked about the prejudice.
Well, it's the prejudice is apparent if you use the standard some of these cases use, which is the hypothetical juror. Would it objectively influence the hypothetical juror? I mean, I think that's that's what the state has to do is say these comments would not affect the hypothetical juror.
But in your brief, you also say that the presumption ought to be irrebuttable. Are you standing by that here today? Or are you wanting us to follow Rimmer and Parker and say it is rebuttable, but you have to use the objective standard on an average juror in considering the effect?
Well,
Irrebuttable would mean new trial.
it is. I would concede that it should be rebuttable, but in a situation like Parker versus Gladden, I don't know how you rebut it. I mean, it may just be it's rebuttable, but there may not be any way to rebut it. So
In some circumstances, the conduct can be so reprehensible and egregious.
So just here is South Carolina Rules of Civil Procedure. They were talking about Rule 606B, inquiry into the validity of a verdict or indictment. So when you're looking into whether or not a verdict or indictment is valid, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations. So the deliberations are going to be what happens in the jury room once everybody's set back there, or to the effect of anything upon that or any other juror's mind or emotions as influencing the juror to assent or dissent from the verdict or indictment. So they can't testify about how anything affected their mind to either agree or disagree with the verdict, or concerning the juror's mental processes in connection therewith, except, we got an exception, influence that was improperly brought to bear upon a juror. Maybe that's where the Becky Hill testimony would come in, this exception. Oh, they may testify on the question of whether extraneous prejudicial information was improperly brought to the jury's attention or whether any outside influence was improperly brought. So, well, that's what I would say is that
Mm-hmm.
Becky Hill's, they could testify if her outside influence
Affected how they deliberated.
was improperly bearing upon them.
Mm-hmm.
go back to the appeal. So
It becomes a de facto structural error.
Well, I read your opinion, Rivera, Court of Appeals, on structural error, where the judge refused to let the defendant testify in a death penalty case. And I've digested, or as my wife would say, digested, not digested, I'm sorry, that case and the structural error analysis.
20
And I
minutes.
must say, Mr. Griffin and Mr. Barber and I
it's hard for an
have
attorney to
had
fit something
a
into 20
significant
minutes.
discussion
Mm-hmm.
whether that would be structural error as opposed to not letting a defendant testify in a death penalty case. It could be, but I don't think we need to go there for this opinion, for this case. I think the clerk of court tells everybody that'll listen, I need a guilty verdict. She tells everybody, so I can make money. She tells everybody, so I can buy a lake house.
Okay, she doesn't.
And then
go
she
right out and
proceeds
say
to
it,
talk to
but-
jurors, not about inconsequential
Roundabout.
things, but
A little embellishment
you know,
there.
focus on the how to view the defendant's testimony and to
really
juror
bad guys,
Z
I can tell, but
and to juror
not
Mhm.
saying that he's not a really
741
bad
into the
guy.
egg lady. Don't believe him. Don't believe his lawyers. I mean, that's, I submit, more than enough to meet the Parker versus Gladden standard or the Cameron standard or I think it's Bennett, the case we looked at. I just looked at yesterday. All of those are cases in which there's no question what was said wasn't inconsequential, wasn't neutral. It was an effect to influence.
Is it a finding of fact or a conclusion of law by Judge Toll where she wrote on page 31 of the record, this court further finds that the improper comments made by Clerk Hill were limited in subject and not overt as to opinion? I know you say that language was put in there by the state in its proposed order. I don't want to talk about that because she signed the order. But is her finding that the statements were limited in subject and not overt as to opinion a conclusion of fact or law?
Limited in subject. So the subject was limited, what she was talking about, and not overt. What the heck are they saying? All right, hold on. We're going to back it up a little bit.
Was said wasn't inconsequential, wasn't neutral. It was an effect to influence.
Is it a finding of fact or a conclusion of law by Judge Toll where she wrote on page 31 of the record, this court further finds that the improper comments made by Clerk Hill were limited in subject and not overt as to opinion?
And not overt as to opinion. So that's interesting. He is saying, so the opinions are implied rather than directly stated, not overt as to opinion. When you're sitting there and saying, pay close attention to him, look into his eyes, make sure he's telling the truth, you're not like, you're saying make sure he's not lying. I mean,
That is overt, right?
it's not coming right out and saying it, but
You're not hiding it or keeping it a
Southern
secret.
ladies, they never come right out and say anything.
Yeah, bless your heart.
Bless your heart. That's interesting. So he's asking Dick Harpootlian if this was a conclusion of law or a finding of fact. So is this a legal conclusion that she was stating? What Dick says is that language was inserted by the prosecution when they were both writing their proposed orders. So when you have a hearing, you submit proposed orders to the court, and the court might take all of your proposed order. They might take some of the proposed order and some of the other parties' proposed order. He's saying that that wasn't something that was said directly on the record during the hearing. Interesting. I would think that this is probably a finding of fact, if you would, or it may just be an opinion. I guess a finding of fact. Otherwise, there would probably be a legal citation with it.
I know you say that language was put in there by the state in its proposed order. I don't want to talk about that because she signed the order. But it
She
is
picked the
her
language.
finding that the statements were limited in subject and not overt as to an opinion, a conclusion of fact or law.
That's a conclusion of fact, which gives rise to a
Okay.
conclusion of law. But that statement is wholly unsupported by the record. And I would submit an abuse of discretion.
And how
Which she said it without saying it. I agree.
about her finding that those comments were
If you can't tell, I'm defense minded. We had a lot of thoughts on this trial.
cured by Judge Newman's overall jury instruction that the verdict was to be based on the evidence presented and the law as he gave it and not on anything else.
Okay, so that's interesting. Judge Newman in the jury instructions told the jury that they are only to consider the evidence that's presented, nothing else. In other words, not Becky Hill's testimony. So the state is arguing that that cures any indiscretions of Becky Hill, because the judge told them don't consider that. If it was that simple, though, even with the 8th juror, if she had been speaking to her ex or whatever the accusation was, then why throw her out? They tell the jurors not to speak to anybody about it, but the clerk of court is speaking to them about the case. So otherwise, wouldn't they get tossed as jurors?
Or be able to go home every night. You know, not watch TV, not speak to loved ones.
Well, I don't think they had them sequestered. This was a long trial, but they weren't
True.
supposed to, which is what happened with the egg ladies on Facebook drama. Facebook.
Well, then you would never have, as long as the judge gave the appropriate charge at the end of the case, you'd never have a case of jury tampering. You could have somebody bribing a juror.
Good
And
point.
according to her reasoning, they well, yeah, I took the money, but I'm not going to do what I said I'd do. I mean, it's
Similar to what I was saying, why would you kick a juror out for any other reason if the judge's instruction was a cure-all? He's just taking it to an even greater extreme. Somebody bribed the juror, which by analogy is what he's saying Becky Hill did. I'm going to make a bunch of money on this book if you give me a guilty plea.
I don't believe for a minute that is an appropriate analysis of the law. Whether I believe it or not is really irrelevant.
And that's something that can be important to show the judge where ruling in a certain way can lead. Yeah, it's a slippery slope argument, but if you rule in this way, you're opening up appeals where somebody's like, yeah, I took the money, but the judge told me not to consider the money I took and how I said I was going to vote, and I didn't consider it.
So the allocation of the burden of proof is not dispositive in your judgment. Even if it was erroneously assigned to you, you believe you met that burden of establishing prejudice because of the nature and frequency, pervasiveness of these comments by the clerk.
If you use the analysis,
So what Dick Arputian is arguing is even if he had to meet the burden of proof and show that Becky Hill's statements affected the jurors, that the frequency, how often she was doing this, and the evasiveness of it, that would have met his burden. So you're arguing two ways. Either I don't have the burden, but even if I did have the burden, I still would have met it, which is smart to argue in the alternative. That way, you're giving the judge more than one way of rationalizing it. Maybe they'll find you're right on one point. Maybe they'll find you're right on the other. Maybe neither, maybe both. But you have more shots if you've got more legal arguments to stand on.
In both the Court of Appeals decision of Green and then the Supreme Court decision in Green, if you look at the analysis, that's exactly what it is. There's not going to be any burden shifting or anything if it's innocuous. But if it is something other than that, then the burden does shift to the state. And we've met our burden. There's no second. She had a two-prong test. Second prong was, did it affect the verdict? Well, I mean, if somebody that can't work for Rule 606B for one, but more.
Okay, that can't work for Rule 606B. Let's go back to 606B. So a juror may testify on the question of whether prejudicial information was improperly brought to the jury's attention or whether any outside influence was bared upon the juror. But they may not testify any matter or statement that happened during deliberations, the effect of anything other upon that or any other juror's mind or omissions as influencing them to assent or dissent from the verdict. Except. So, yeah. I don't know if I agree with him there. That seems to fall within the exception, but they're discussing a case where this was brought up. Well, I would say under 606B, that would be that exception of undue influence.
Mm-hmm.
Now, that part right there, the year later, the time, breaking down what influenced you then and what influences you a year from now,
Mm-hmm.
that's difficult. You're not in the moment anymore.
No.
Oh, I have no idea if anybody's watching with us or commenting with us, but we'll check the comments later. We're just sitting here watching. And Channel Surfers, if you're here, hi.
I did
Oh
manage
my
to get
gosh, we're going back to Aaron Burr. Oh, Dee's on the camera.
Yeah, I went and put my face on.
Looks great.
Sure, whatever.
We're going back to Aaron Burr.
You're not sharing it.
Indifferent as he stands
Sorry,
unsworn,
we're going back
his
to Aaron
verdict
Burr.
must be based upon the was,
Oh, here.
Did it affect the verdict? Well, I mean, if somebody that can't work for Rule 606B for one, but more importantly, you're asking jurors to unpack for you what influenced their verdict. How did they get there, which you can't do under 606B, and people can't do, period. I mean, if somebody had walked in there with a gun and threatened everybody, and then left, and the jurors are polled a year later saying, no, I thought the evidence was overwhelming. It didn't matter whether somebody walked in with a gun or not. And overwhelming evidence is not the standard. You know, this Sixth Amendment, I was going to go somewhere historical. I'm not going to do that. But yeah, I am. The Sixth Amendment was based on, as you know, English common law. In the trial of Aaron Burr in 1807 for treason, this is not for killing Hamilton, this is for trying to sell part of the United States to Mexico. He was a piece of work. Chief Justice Marshall
These people
quoted
are
from
smiling
Lord
in the
Cook,
galley.
or Coke, who said, "A juror must be as indifferent as he stands unsworn. His verdict must be based upon the evidence developed at the trial. This is true regardless of the heinousness of the crime charged, the apparent guilt of the offender, and the station in life which he occupies." You can't say it any clearer. And that's what the Sixth Amendment guarantees. And that didn't happen in this case.
We understand that everyone,
Oh man, when you got to reach back that far though to prove your point. Not that he has to. I just don't know how persuasive that is.
Mm-hmm.
regardless of the heinousness of the offense, the character of the accused or the apparent guilt of the accused in no manner diminishes the right to a fair trial. In your effort to set up that this is a man for all seasons moment, we understand the gravity of the situation and the entitlement of every individual to a fair and impartial trial.
Your Honor, I never doubted that for a moment. I think I was saying that more from me than you, because it's such a great quote. And again, came up during Aaron Burr's trial, who's such a terrible person.
Remember when we
But
watched
even he was
that?
entitled to a fair jury.
He's
You
got
know, we
yellow
quote
light.
in our brief, and I want to expand on it just a little bit. If you look at United States versus Elbaz, which is a Fourth Circuit case written by our own Jay Richardson, he details what Remmer requires, what to trigger the presumption, the defendant must introduce competent evidence of extrajudicial juror contacts that are more than innocuous intervention. I submit we've done that in this case. But the presumption's rebuttable. The government defeats the presumption by establishing there exists no reasonable possibility that the jury's verdict was influenced by an improper communication, which was not done in this case. And you should exclude, well, at least one, I would point out a quote.
He is wrapping this up really fast. I got to listen to that again.
And again, came up during Aaron Burr's trial, who's such a terrible person. But even he was entitled to a fair jury. We quote in our brief, and I want to expand on it just a little bit. If you look at United States versus Elbaz, which is a Fourth Circuit case written by our own Jay Richardson, he details what Remmer requires, to trigger the presumption, the defendant must introduce competent evidence of extrajudicial juror contacts that are more than innocuous intervention.
So in order to trigger the presumption that the statements unduly influence the jury, you have to show
Tells what Remmer requires, to trigger the presumption, the defendant must introduce competent evidence of extrajudicial juror contacts that are more than innocuous.
evidence of extrajudicial, so outside of the courtroom, juror contacts that are more than innocuous.
Mm-hmm.
So you could still have a indirect statement it doesn't. He's saying more than harmful or offensive. meaning you don't even have to meet that standard under, he's arguing again, the Fourth Circuit. He's going under the federal law.
Was intervention. I submit we've done that in this case. But the presumption's rebuttable. The government defeats the presumption by establishing there exists no reasonable possibility that the jury's verdict was influenced by an improper communication.
So once that presumption arises, once you show that Becky Hill was sitting outside of the courtroom, chitty-chatting away, then it's up to the state to show the court that there's no way that had an impact on the case. I don't know. One thing that kind of comes back to me is the dog video.
Where about the dog's tail.
Well, the dog in the video, and you hear Alex still there.
In the background, yeah.
Yeah.
Hmm.
Although, I mean, it's been a couple of years.
Which was not done in this case.
But maybe the timeline could have worked. I can't remember. I just remember thinking, they might not have met their burden.
I
It's
remember
a
me
high burden.
me and you were arguing about it, and I kept saying the timeline is what has me convinced.
Yeah.
The timeline was huge for me.
I just didn't see, not that they have to prove motive, but
Yeah, I'm still confused on motive, but the timeline.
You should exclude, well, at least one, I would point out, Juror Z said it did. I mean, if we're going to go that way, now it may have been ambivalent. Judge Toll says, I said in the record, it can be both pressure from the jurors and what Cork Hill said. But I don't think we need to go there because 606B and almost all the cases about external influence don't allow you to ask the jurors questions about how they got where they got.
A part of Parker versus Gladden was that the Sixth Amendment was violated because the bailiff there who said this person's guilty, this wicked fellow, whatever, became a witness in the case. Is that what you're saying Clerk Hill became in this case?
Well, not necessarily. What I'm saying, Parker versus Gladden, they
Was
only need
she,
10 or 12 to get a conviction.
character
And
witness?
Oregon Supreme Court said, well, we had 10
Did
that
she
weren't
make herself a
influenced
character witness?
by whatever the
My thing
bailiff
watch
said.
this hand.
The Supreme Court said very clearly, doesn't matter. You're entitled to 12 impartial jurors. Also, that was the case in which the United States Supreme Court adopted through the 14th Amendment, the Sixth Amendment to the states. So that's the reason I like Parker, because it's got so many.
And here's the importance here. Once a court rules a certain way, then other cases have to go by that same logic. Do we want other cases coming up where the clerk of court is going around making these comments and there's no relief for the person? I mean, this may be a much more clear case of what happened, but let's say it's something that's really on the fence there.
Exactly how many jurors did she talk to?
She was talking to them all in the hallway.
So she was making that comment to all the jurors.
She's like, hey,
collect-
guys, we're going in today. Y'all pay real close attention to what he's saying.
Gotcha.
Like, what if that was happening in the DUI case from up north? Oh my gosh. Why can't I think of it? I can see her face even though I don't have a visual memory. Karen Reed.
Mm-hmm.
Like, what if I mean, a different state, but what if that was here? And what if the juror or the clerk of court was like, y'all listen to her, she's a liar, or pay close attention to what she's saying,
Mm-hmm.
watch her moves. So you can see, like, you've got to protect everyone's right to a fair trial, because once the courts rule a certain way with a certain logic, then you're bound by it with the president.
Different levels that are very helpful in this case.
And in Parker, did it took 10 to convict in Oregon, right?
Yes, sir.
How about Judge Toll's finding that even if the state had the burden, she found any possible presumption of prejudice was overcome by the facts and the court's findings? So she did conditionally rule that if I'm wrong about the burden, then the state has overcome that burden.
I like that. So Justice Toll ruled in the alternative. She said, I'm going to say it this way, but even if I'm wrong, I'm going to say that they still had enough to find guilty, which is what we're going to see the state argue here in their response. That was their brief.
Well,
The presumption, excuse me.
two things. One, she doesn't detail what that overwhelming evidence is. And we're going to hear from Mr. Griffin in just a moment as to how underwhelming that evidence is. Number one.
So she doesn't lay it out in the record.
Number two, that can't, the level of, if the level of evidence dictates whether or not you get a fair jury, then again, we go back to what Judge Marshall said, no matter how heinous, no matter how overwhelming the evidence, you're still entitled to a fair trial. I mean, if only the people that may be innocent get a fair trial, then our Constitution isn't working.
So what he's saying is Justice Toll's end, where she's saying there was plenty of evidence to convict him. Well, that doesn't deny him the right to have an impartial jury. Just because there's a lot of evidence doesn't mean that he should not be entitled to an impartial jury, which makes sense. Fair jury should be for everybody, especially in cases where the state feels they have a lot of evidence. I mean, Karen Reed, they felt they had so much evidence, they tried it twice.
Mm-hmm.
I don't care. I would submit this court shouldn't care. No one should care when there's a Sixth Amendment violation like Becky Hill committed in this case. And let me say this. I know my time's up. We spent months getting ready for this trial.
So he's saying guilty or innocent, we've got to protect the Constitution, which is why he started off his speaking today with the oath he took to uphold the Constitution. It's all coming full circle.
Weeks, 6 weeks trying this trial, more months.
He's like, I'm not here necessarily to defend Alex Murdaugh, which, yeah, he is. But when you're arguing in front of the Supreme Court, that ruling has repercussions across the state. Like criminal cases that we do would be impacted by this ruling.
Finding jurors to talk to and find out if the court could talk to her.
What will be the test if another clerk in the Low Country starts running their mouth to jurors? Of course, they would face criminal punishment. But how do we decide if the defendant got a fair trial?
Or talk to them. We had more hearings, more briefing. Nobody wants to do this again less than we do. But that's not the issue. It's
like
not how
not
much
getting
trouble it's
paid
going to be.
anymore.
It's what is Alec Murdaugh guaranteed to under the Sixth Amendment.
Thank you, sir.
Thank you, sir.
All right, Creighton Waters.
Good morning, Ms. Waters. Good to see you, sir.
Good morning, Chief Justice Kittredge, and may it please the court. I'll start out with my 5 minutes, and I'll start by saying I also agree that oaths are important. That's something I always talk about with juries and the importance of their oath. And I think that that's also recognized very strongly in this court's case law and case law of other jurisdictions. And that this court has expressed that jurors are presumed to take that oath very seriously, that they're presumed to be people of ordinary
I
firmness,
like this.
that they are not.
Creighton. So Dick gets up there and starts out with the oath as an attorney, and then Creighton jumps in and talks about the oath as a juror.
Mm-hmm.
And what are we talking about? The jurors here and their oath to
Not-
presumably ignore everything Becky Hill says.
Not presumed
Sorry.
to blow with
But you know what? To be fair, this is the lady bringing you lunch. So
Well, I was sitting here thinking, what would be the difference if somebody just jumped up in the middle of the courtroom and said, right before he gets on the stand, you have to pay attention to him. He's a liar. Watch him. I mean,
because then you would have Dick Harpootlian jumping up and potentially calling for a mistrial.
I know.
It would be right there in front of everybody.
Mm-hmm.
Or, you'd have the judge say, okay, that's not true. But I mean, I'd move for a mistrial.
You need to
at that point,
disregard what that person said.
which he's going to say anyway. But
Right.
that's the difference. And that person's not bringing you lunch every day. I mean, I'm going to like the lady that's bringing me chicken salad sandwiches and peach cobbler. I'm just saying. Aren't you going to listen to her?
Probably not.
I could be objective, but food can influence me
It
the
definitely
winds of every
influences me.
when I'm hungry.
opinion that swirls
So let's hear what he says about the jurors.
around them. And so I think that's an important place to start when we look at this particular case. And when we look at this particular case, what we are talking about is what Justice Toll described as a few fleeting comments. And in the face of that, we have to consider a 6-week trial with almost 90 witnesses, with almost 600 exhibits, with Judge Newman, with the entire prosecution team, with the
Okay. And that being said, you've seen Becky Hill every day. Maybe you want somebody to sum it up for you at that point. Maybe you want somebody to wrap up the 6 weeks and tell you what to do. That's exhausting. I mean, it was fun. It was fun to
Yeah,
watch.
but he also started with talking about the oath that the jurors took. So not talking to her about it
Right.
or asking her questions shouldn't
But
be
now
what's-
what he's saying is that you got to consider these are a few fleeting comments, but it's a long trial, trying to say that in the scheme of things, it's just a few drops in the bucket, where
Mhm.
counter argument is that's a lot to take in. You've got this one person that you've built up some rapport with, seeing them every day. Maybe you're looking for somebody to put it in a nice little box for you and tell you how to rule.
entire
Because it's a lot to take in. So maybe that means more to you. And also somebody that you would think has experience. This is the clerk of the court. She's seen a lot of trials.
defense team and
So I don't know that that argument works.
all of that presentation over 6 weeks.
But I see what he's saying.
And to get there and to do what ultimately is the analysis is we have to assume that at some point prior to deliberation, during the presentation of evidence, with all of that going on, some jurors like, well, I didn't know what I was going to do, but Miss Becky said, watch his body language, and that made the difference. And I would submit to you that that is simply not a finding that is justified in this evidence. It's not.
All right. Well, the jurors also are not supposed to make up their minds until the end, until deliberations. They're supposed to keep an open mind throughout the trial. So defendant's testimony is also one of the very last things that you hear, but you're not taking that back into the jury room. I mean, it's like one of the last things you hear before you go into the jury room. So he's saying that like changed their mind in the moment. Do you see what I'm saying? On the other hand, they're not supposed to be making up their mind at that point.
Mm-hmm.
Not to say
Yeah.
that people don't make up their mind early on, but that's part of the instructions not to. So if the courts are instructing you not to, then you might not want to base your legal argument on them making up their mind midway. I don't know.
Not a finding that's justified under what we know about jurors, and it's not a finding that's justified by what the jurors said in this particular case. Now, to sort of detail my my analysis in my free 5 minutes that I have here before the questioning comes, is we have 606, and we've got two issues. We've got number one is what happened. And then we've got number two, which is how do we analyze that particular issue? And when we start with what happened, that is obviously a credibility and fact-finding effort by the trial court. This court is very clear that the trial court, because this is not like a trial, this is a procedure that is in the discretion of the trial court, and ultimately any credibility findings, fact findings, this court respectfully would defer to. And so to determine that, what exactly happened? And this court ultimately credited the 11 jurors. And so what do we have with those 11 jurors? We have one juror saying that Ms. Hill said this is an epic day and the defendant is going to testify. All right. And then we have another juror who says, watch his body language. And beyond that, the court clearly did not credit Juror Z. And I'll get into more about that, but there's plenty of the support in the record why the court could not credit what Juror Z said. Juror Z was ambivalent. Her answers were all over the place. None of the other jurors heard all those egregious statements. She couldn't even remember all of these egregious statements when she was on the stand.
A year later, she didn't feel comfortable, though, saying it didn't influence me. I don't know. I think the ambivalence should weigh on behalf of the defendant. And it's a sticky situation. What do you think?
I don't like what's all of the stuff that Juror Z is saying that was said.
Well, what he's saying is why we don't need to worry about what Juror Z said, because he said that Juror Z was ambivalent. Juror Z was like, well, I don't know if it impacted or not, or yes, it did. No, it didn't. And he's saying that shiftiness means that I guess she's lying or not credible. I think that just has to do with the passage of time, and you're asking her to recall everything about her decision, and she's sitting there saying, yeah, she did say it, but maybe that did. And now maybe she's sitting there going, did that impact it? And not remembering every little thing that went into her verdict over a year ago. I don't think you attack her credibility there, but I mean, the passage of time, that would just go in favor of the state, and appeals aren't immediate. They take time. I mean, it's been 2 years.
She said, I don't remember them. All of these things that really would take this analysis into a different level, she didn't remember. So when we boil it down to what happened, we're talking about epic day. All right, epic day.
He's saying that she didn't remember those things. It seemed to me that one juror said, like, kind of like changed their mind, and they tried to get that juror to come back out. It's like after they started thinking about the question, but they denied that.
Everybody in the courtroom knew it
And see, it's been so long, I can't even remember.
Yeah, I have trouble recalling some of it.
was an epic day. That is not news to anyone. Everybody knew it was an
Mm-mm.
epic day.
That's true.
It is rare for a defendant to testify. That on its face is a neutral comment. That is not necessarily a comment one way or the other. And if anything, we've seen where instances of a jury in deliberation considering the fact that a defendant didn't testify, saying, he must be guilty because he didn't
Mhm.
testify. That's actually been an inference that goes more.
Well, it's rare for a defendant to testify, but, and maybe this is what Justice Hull meant by it being not direct, by pointing out that he's testifying and then saying, watch his body language. What does the body language part say? Like, we can't look at these in a vacuum. This was said along with things like watch the body language.
True, but I would think that, that's one of the signs everybody says to watch people for lying and stuff is to watch their body language. They
Right.
probably didn't even need that kind of a reminder. We all kind of know that. I'm sure everybody was going to be watching
But
his
when
body
somebody
language.
is saying it's like all together, it's an epic day, defendants don't usually testify, watch his body language. You're saying he's doing something weird here. Make sure he's not lying.
In favor
I
of the
underst-
defendant than against.
I understand what you're saying. To me, it's just kind of stating the obvious, but it shouldn't have been said to them.
The obvious is make sure he's not lying, not look for the ways he's being truthful. You're gonna, what if that, let's switch it around. What if she was saying, this guy's so, look, you're going to see how honest he is. Look in his eyes. You're going to see the truth. You're going to see he's honest and a God-fearing, family-loving person. But the guy's guilty as sin.
Mm-hmm.
Flip that around. Wouldn't you be like, well, that's not fair. You shouldn't be implying or even directly saying, but even implying, oh, he's such a good person. Just look in his eyes.
Mhm.
I've known him for a long time. Cut it both ways. Becky's job
She
wasn't,
should have made no
she
comments.
shouldn't have made any comments.
Exactly.
Should have snacked on that chewing gum, blew some bubbles, had her coffee.
Him, the fact that he's testifying. But again, it's rare that a defendant will testify. That ultimately is a neutral statement as well. And then watch his body language. Again, that is what was found. Not don't get fooled by his comments or anything like that. That was not what was found.
Don't get fooled by his comments.
That's way over the line.
Again, don't look at these statements in a vacuum. Let's look at them all together.
She's saying he's a liar without saying he's a liar. Or that he's guilty.
Basically describing a liar.
Mm-hmm.
By the trial court, just a neutral comment of watch his body language. And so that is the facts, the three facts that we have
A
to
neutral
ultimately-
comment of watch his body language. But like you said, Dee, you know that she's saying look to see if he's lying.
Mm-hmm.
But Creighton's going to try to say this was neutral.
assess. So when we
In other words, oh yeah, just watch his body language. There's nothing bad about that. I don't know. That inference seems to be pretty well known. It's not some obscure inference.
move on.
Well, saying it along with mentioning his comments, that's what took me over the, okay.
I mean, this stuff can't happen.
Mm-mm.
This stuff cannot happen. Courts are set up to try to ensure fair trials. That's why we have rules of evidence. That's why things that you might see in the news don't come in court, because the rules of evidence are supposed to make sure that what we get in are credible and reliable statements. Did she just get this guy a new trial? Maybe, maybe not. We're going to find out.
She'll be writing
Should
a
she
damn book
have?
about herself.
Actually, I'd read it.
Mm-hmm.
On from there, then
But remember, she also plagiarized part of that book. So,
the analysis is how do we analyze that? And first of all, we have the discussion of whether or not there's a presumption of prejudice. Justice Toll, of course, found based on this court's clear case law that there was not, but I would agree.
so what a presumption is, it's when the law goes ahead and says, okay, we're going to just presume that there's prejudice. We're just going to go ahead and say, yes, there was prejudice. And then the presumption can be rebutted, meaning that you can prove there's not prejudice, and that's how you get over it. So basically, you don't have to prove there's prejudice. The law is already going to give you that point. And it's up to the other side to take that point away.
Submit to you that not only because of the alternative findings, but just because of a general analysis that regardless of who had the burden, that presumption of prejudice was overcome in this particular case. And I'll talk more about that in a second. But I think ultimately the legal analysis, whichever way you go, I don't think is going to be dispositive because of the relatively non-egregious nature of these comments. They are nothing like the comments that were in the cases that have led to reversal. So,
Okay. So he is distinguishing this case from the other cases that they're talking about. Green, Parker, which I think is an Oregon case, distinguishing it by the nature of the comments. He's saying that this isn't as bad as those. But where do you draw the line? What tests do we use to decide like what level of bad it has to be? And that's what we're going to talk about.
let's talk a little bit about more of the findings that were there. In looking at the evidentiary hearing that was done, we had, of course, Ms. Hill testify, and the judge found that she was not completely credible. We had Ms. Rhonda testify. The court did not credit that testimony because Ms. Rhonda conceded over and over again that she absolutely heard nothing whatsoever of
Mr.
any.
Waters,
Yes,
I
ma'am.
want to stop you right
Yep.
there, since your 5 minutes is up, and talk a little bit more about Jersey.
Yes, ma'am.
You're saying these are innocuous comments, not to be fooled, and look at his actions, look at his movements. The court seems to believe Jersey when she says in her affidavit and when she testifies that these comments were made to her. However, she goes on in her affidavit to say, not to be fooled, which I understood to mean Mr. Murdoch would lie when he testified. Look at his actions, look at his movements, which I understood to mean that he was guilty. The juror is testifying in her affidavit that the effect on her was significant. Why can the court, how can the court find that certain comments that she made, take them and incorporate them in the order, but not believe what she says about the effect?
Well, two things about that. I think that, first of all,
Well, good
Justice
point.
Toll did not credit any of the egregious comments that she didn't even remember herself on the stand, such as "won't get fooled." The only comment that
She's like, well, Justice Toll just threw all the stuff she said out anyway because she couldn't remember on the stand.
was credited was what was testified by Juror P, which is watch his body language.
And let me, and I want you to finish your answer, but I want to ask you this. So far as the comments are concerned, are we limited, is this court limited to only the comments that are included in Judge Toll's order? Or are we able to consider all the
Full
comments
record.
that are included in the affidavits, even the egg juror affidavit?
Well, what I would say to that is the case law is clear that the trial court has the discretion to conduct this hearing and ultimately make credibility findings, which under typical appellate law, this court would defer to. And so my argument to that is if you look at Justice Toll's order, both her oral order and her written order, she credited the 11 and did not credit Juror Z and did not give any credence to 741, the alternate, and or the egg lady, which of course did not testify. Now, there was on page 808 of the record where she says, I think we've got in terms of what she says, Ms. Hill says, and what Ms. Hill says she says. That's on page 808 of the record and talking about the egg lady juror.
Yeah.
But ultimately, I would submit that this court in appellate review does need to defer to credibility and factual findings of the trial court. And the trial court only found the 11 credible. And
Well,
when
then
you look-
help us
But never
understand
talk to the egg lady.
the ostensible inconsistency when the trial court finds portions of Juror Z's affidavit credible and just carves out and doesn't deal with the part.
Picks and chooses when the court thinks that this person is lying.
Or credible. Yeah. Remind me, was egg lady part of the final deliberation?
No,
I didn't
she was
think
taken
so.
out right at the last minute. What do you think about the questions we're seeing for Creighton versus what we saw for Dick? I feel like the court is,
They're digging deeper.
I feel like they're coming at him harder
Mm-hmm.
about these inconsistencies.
Mm-hmm.
That dovetails with the alternate jurors' testimony, which is far more prejudicial.
Sure.
How do we
and-
do that?
Well, so we're looking for, I would submit from an appellate court's standard of review, we're looking for support in the record for those findings. And so when you look at Juror Z, okay, and first of all, you look at the 11, which she did credit, and none of those 11 heard any of these other egregious comments or anything like that. None of
What do
them
we
heard-
do about the order that doesn't even mention that Juror Z did in fact testify
Oh,
about the comment, "Don't let the defense confuse you"?
it wasn't even in the order.
Well, I think that when you look at the order in her specific
Mm.
paragraph on Juror Z, what she says is that Juror Z was ambivalent. And ultimately, as she goes through the analysis of what Juror Z says, she's not crediting that testimony. And again, I think there's support in the record for that.
There
I
may
underst-
be, and that may carry the day for you.
Right.
Assume that we find that that statement was made. Do you still have a path to victory?
That don't be fooled.
At the end of the state's case, before the defense presents its case, the statement was made, "Do not be confused. Do not be misled by defense and its counsel."
Well, I would say
That's what he's saying. Like, are we allowed to look beyond the record? If we're stuck with the record Justice Toll gave us, this didn't even make it into the record.
Mm-hmm.
But what if we do find it? DUN.
and this is like everything in this, it is a question of degree. Okay. And there
It's a question of degree. But like Dick Harpootlian said, it's not degree. Even the worst people are entitled to a fair trial.
Mm-hmm.
Thus his Aaron Burr argument.
could, if the clerk had come in there and held a gun to their heads and said, "You better vote guilty or I'm going to shoot you all," I probably wouldn't even be arguing that's not structural error. Okay. But everything is a question of degree.
Oh no, Creighton. He says I probably wouldn't be arguing this. Please, if Becky Hill went in there with a gun, please tell me you would not be defending this appeal. Please. Please tell me you wouldn't be touching this. You'd just be like, yeah, you're right. We're gonna give you a new trial. Oh my goodness. I probably wouldn't. Creighton.
I'm not going to concede that if those statements were credited and are part of the review, that our path to victory is not harder. But
We're talking about duress though, which isn't the standard. On 606, outside influence improperly brought to bear upon that juror. Extraneous prejudicial information improperly brought to the jury's attention. It doesn't say holding a gun to one's head.
Mm-mm.
I think you have to look at that in the context of this entire trial and when those particular statements were made.
And I think context is important too.
Which is what I said. How do we determine that line? Okay, he's about to get into context.
We all can cherry pick some of these that are on the surface innocuous. Epic Day, Big Day. And when viewed in isolation,
Agrees.
they don't move the needle, arguably.
This is what I
But when
said.
those seemingly innocuous statements are considered in the aftermath of the originating statement, not to be confused and misled by the defense, those initial innocuous statements take
That's
on
exactly
a
what I
very
said.
nefarious message.
I could not argue otherwise, that would absolutely be a question of degree. However, I don't believe that just ends the inquiry right there, because you still have to analyze it in the context of all of the factors and everything that went on. And so to look at that, let's look at all of the things, and let's assume that we're limiting it to what I contend Justice Toll found, which again, when I say innocuous, I'm saying relatively not egregious. I'm not saying that the clerk should be saying, watch his body language, okay? But that is a far different comment from what you're talking about right there. But
Yes,
even if
sir.
we add that in, we're still talking about a limited, number of jurors who saw that. And then we're putting that in the context of where that occurred, okay? It occurred during the middle of the defense case, not during deliberations, not right before deliberations, but in the middle of the defense case. It occurred during, I think we counted no less than 60 times that this jury was told by Judge Newman to only, rely on the evidence, to not talk about the case, to not have external influence and all the rest of that. And we have to credit that. We also have to, again, put that in the context that when and if that occurred, and even assuming that there was a one bit
She was
beyond
told
that,
enough, wasn't
that
she?
it was attenuated from the actual point of deliberation
listening to
by
her
the rest of the
ex-husband
defense
anyway.
case, by the entirety of the state's reply case, by all of the closing arguments of counsel, and by Judge Newman's very
These people
detailed
look
charge.
concerned.
And so while that would be different, I don't think that is fatal when you look at the entirety of this 6-week trial. And again, go back to what I said ultimately at the beginning of my argument here is that for that to happen, you'd have to conclude that with all of that going on, with this massive evidentiary presentation, with multiple instructions from the trial judge, with all these arguments of
So
counsel.
you're distinguishing a day and a
The longer the trial, the more opportunity there is that some sort of comment slips in there.
Hmm.
Those are the trials where you really need to make sure that you need to do it in every trial, but if it's going on 6 weeks, you got to make sure every day you're going in there and crossing your T's and dotting your I's and not telling the juror to pay attention to this man. He's a liar.
Mm-hmm.
half long burglary third trial from this trial.
No, sir. But what I am
That's what
saying
he's saying. Tell me the difference between a day and a half long burglary, third degree trial, and this trial. Why are we distinguishing the length?
is that I do think time matters. I do think
Okay, but you would agree that at the end of a Berg third trial with a guilty verdict, the judge finds out that the clerk of court was back in the jury room saying something like, well, that defendant's not going to testify. But I just want to let you know, this is the 5th time he's been up here for a burglary third. So I just want you to know that.
Right.
Egregious or not?
Your Honor, if that were the case, I would be very hard pressed to argue otherwise.
Okay, so
Mm-hmm.
help me out with this. If we craft a standard based on the length of a trial,
Mm-hmm.
and heavens know, nobody wants to try this case again. How do we create a standard based on a lengthy trial versus a day-long trial when the constitutional right is the same?
Oh, I would argue that you have to be more fair more careful during the lengthy trial to protect the Constitution. And like I said, you're going to wear people out after 6 weeks. They are probably more apt to just grab onto something that makes sense. Look, this nice lady bringing her lunch. says the guy's a liar. Works for me.
Absolutely, the constitutional right is the same. And what I'm not asking is this court craft a different standard for
What
a
are you
long trial
asking,
versus a
Clayton?
short trial.
What are you
What I
saying,
am
Clayton?
saying is what is relevant to the ultimate inquiry that this court engages in is the timing of when these comments took place.
Okay, well, let's talk about that, and I'll
Mm.
weave in
Timing
some
should
questions
never.
about the egg juror. Ms. McElveen, the Barnwell County Clerk of Court, said she didn't hear any of these comments made in front of jurors, but the comments made to Ms. McElveen by Ms. Hill were remarkably the same as those related by the jurors. For example, watch him closely, look at his actions, look at his movements. Ms. Hill was saying that to staff and to Ms. McElveen. You agree that's what she testified,
That's what
correct?
she testified to.
That does match almost exactly what these jurors said Ms. Hill told them, correct?
It
Credibility.
is.
Okay, so explain to me how we pass go under your theory.
Ooh, monopoly.
How do we accept the fact that Judge Toll maybe didn't mention all these things in her order, but they were supported by an impartial witness, that being the clerk of court from Barnwell?
Well, two things about that. I don't think we can get past what you've recognized, that clerk of court from Barnwell heard nothing going to a juror, or she would have brought that to the court's attention.
But the consistency of the comments or the similar nature of the comments is striking.
Well, and then my second part that I would say about this is that all of this arose months and months and months after trial. And the courts have been historically reluctant because of that passage in time, because of the fact that jurors vote one day and one day only, and don't have to assent to their verdict and vote him.
So if you can get away with it for 6 months, then you're in the clear. Is that what we're saying here? If you can influence a jury and nobody finds out for 6 months, you're good.
Guilty every single day for the rest of their lives. And so I think that passage of time is something that is relevant.
I agree. The passage of time is problematic, but you're trying to use it to say people aren't credible because of it. And that you can just kind of get away with an unfair trial.
As well, when this case is being talked about incessantly out in the world. And so I think that that's something as well that Justice Toll can consider in deciding what actually happened, and the best evidence of what actually happened, and whether or not it is, whether you look at what the jurors said about it, not to get to the 606 aspect of it, or if you're objectively standing back and making that factual finding of this is what happened and this is whether or not there's a prejudicial effect. That is why Justice Toll credited those 11 jurors, and that is, I would submit to you, the realm of what this court needs to consider.
Credited those 11 jurors who had the same passage of time. And maybe this is where Dick's argument about the presumption coming up makes sense. You give the defendant the benefit of the doubt because of all of these issues.
Mm-hmm.
And to prevent Becky Hills from saying, pay attention to this liar.
I want to ask you a question about this idea that you expressed, that this event or these moments when the clerk spoke to the jurors should be considered insignificant when viewed among the entire trial, whether it's long or short trial. There's no eyewitness, there's no DNA, there's no one thing on the part of the state that you could rely on to show him guilty. So you had to piece together a whole bunch of different stuff. We'll talk about a lot of that stuff in the next phase. But
yes,
but you spent, most of that 6 weeks was you piecing together small pieces of evidence to put together an argument that he did it.
Ouch.
On his side, now, of course, he doesn't have the burden and isn't even required to testify. But on his side, whether he's guilty or innocent boils down to one moment, one thing. And that's when sat up on the stand and said, I didn't do it.
Mhm.
So what I'm wondering is, you're wanting us to consider the statements by the clerk to be insignificant, but those statements go to the only thing that the defendant really had. I mean, the defendant can argue that you didn't piece it all together.
Was that he was the only one that testified for his defense. Did they call other witnesses?
I can't remember, but I mean, honestly, I wouldn't expect any defendant to say anything different.
Well, I wouldn't expect any defendant to say anything, but
Yeah, but I mean, I don't expect one to get up on the stand and say, yes, I did it. So I see what he's saying, but at the same time, I don't really see.
what if it's self-defense, D? What if they're like, yes, I did it, but it was justified? Not this
That's
case.
different.
Anyway,
That's different. We
But
watched
really,
this
the
for 6 weeks.
Defendant's
and I can't remember. It was 2 years ago.
argument
So how are any of these jurors credible? We watched every single day of this trial.
boils down to the one thing that the clerk of court addressed. So we can look at all this context if you want to, but the jurors knew that if Ellett was telling the truth, he's not guilty. If he's lying, he is guilty. And that's where the clerk of court's statements appear to focus. How do you respond to that?
Well, I would say that while I understand that obviously was very important, the defendants taking the stand, it wasn't as simple as just getting up.
Okay. Yeah. He had 14 witnesses. But what the judge is saying is the only time that Alec gets to say his side of it, you spent 6 weeks telling your side of it. The one time that he gets to tell his side of it, the clerk is basically like, watch his movements, listen to his words, make sure he's not stretching the truth.
Up there and saying, I didn't do it. Okay. And while there was a long piecing it together of all of that, the defendant's testimony was also very long over the course of 2 days. And
2 days versus 6 weeks. Oh, Creighton. Oh,
so,
sorry, 6 weeks.
I don't think that you can just view the defendant's testimony entirely in isolation of this entire trial. I don't think.
And I guess he's saying, there were other defense witnesses. Like the court said, though, they don't have to prove anything. They could just say you didn't meet your burden.
Mm-hmm.
But what they're saying is the one time he gets to tell his side of it, even when the other witnesses are up there, even when you have a different coroner talking about the appropriate way to test for body temperature, through the rectum with a thermometer, not under the armpits to determine time of death. That's not Alec telling his side of it. So that's at least the point I was taking from the justice. I don't know if Creighton is hearing that question the same way.
Any analysis that has ever said that we're going to ignore the entirety of what went on. Certainly the defendant's testimony was important, but they had been raising all kinds of issues as to lack of motive, as to other possible motives, as to the boat case, as to the Cowboys, and all these other things along the way as well. Again, saying this is an epic day, saying it's rare for defendants to testify, those were all statements that everybody in that courtroom knew. Everybody in the
Oh, come on. In isolation, they already explained to you their problem with that, Creighton. Don't throw it in.
that courthouse knew. So while I hear what you're saying, I think that you can't take out the fact that this was a complex matter with a lot of complex issues.
And, to the extent though, that you've made some fine points about how we should interpret the statements. But if the statements, and Justice Kitchens was alluding to this, if the statements kind of collectively go to the point you should not believe him, to me, it's hard to separate that from the critical issue in the case. But I want to bring up one other thing. You point out in the very beginning of your argument that the trial court here found that Becky Hill was not credible. Now that's a soft statement. That's almost like Richard Nixon or Bill Clinton, whoever it was, said mistakes were made. Sometimes
Gotta
people are
love
not
that
credible
passive
because they
language.
didn't get a good look at what occurred. Sometimes people are not credible because they don't remember what they saw.
Right.
Here, if Becky Hill is not credible, it's not because she didn't see it. It's not because she doesn't remember it. It's because she's a liar. Is that right?
I would say that ultimately she said she was not completely credible. And yes,
She got
yes, sir.
charged with
So there's only one way
perjury.
that Becky
So,
Hill
yeah.
can be not credible, and that is that she is a liar.
I think that Justice Toll did not credit parts of her testimony as she looked at
She
everything.
got
Now,
charged with
she didn't
perjury.
specifically find that she is a liar, but ultimately she didn't credit that testimony. But what I think is important is that neither Justice Toll nor the state relies on Becky Hill. What we rely on is what is most important, and that is the 11. The overwhelming majority of
But you're
these
gonna
jurors who
say
sat there
the
and looked
other jurors
Justice
that
Toll in the
aren't
eye,
part
who
of the
judged their
11
demeanor, who judged their credibility,
aren't credible
and
because they
who
can't
ultimately
remember,
were
even though
clear as a
you
bell
acknowledge
that
an
there was
issue
no sort of
with
improper
remembering
influence
after
on
the
their
passage of
verdict.
time.
And when you look at these questions and you know, whether or not they went beyond 606B, ultimately they were questions about impartiality. And I think there's a distinction, and Justice Toll made this distinction that when she phrased these questions, first of all, she had the 4 exact questions that were in green, which I understand the footnote, Justice Hill, when you were on the Court of Appeals, but they were the same 4 questions from the record in State versus Green. So that was a reasonable set of questions to ask. I see I'm out of time, but
You premise your response that she relied on 11.
Mhm.
In Ethier, this court overruled Vestry versus Orkin exterminating, and that a party is entitled, and that was a civil case, 12 impartial jurors, not
Ooh.
11.
yes, sir.
Ooh, and that was
So how do we deal with that?
Because ultimately the 11 were credible and Z was not. And that is what Justice Toll
Oh.
clearly found. And when we look,
And how do we handle Ms. Hill with, as I think Ms. Harputner referred to one of the comments, that Ms. Hill was attracted by the siren call of celebrity. There's another quote
Siren.
in the trial court's order. She allowed her desire for public attention
makes
to
sense.
overcome her duty
Irene, oh, no.
to her oath of office and her oath as a witness.
yes, sir.
How do we
I do
deal
love
with that and pick and choose what parts of her testimony we accept or don't accept? We just refer to the trial court.
Well, I think when we look at Ms. Hill, and again, I'm not here to justify or to defend Ms. Hill. Ms. Hill, of course, said she didn't do, any of these things other than, occasional, just everybody pay attention, you need coffee and things like that. But so I think that ultimately Ms. Hill is she didn't admit to any of those things. So you have to look at Juror Z. Juror Z is what's really in play as to whether or not Ms. Hill went beyond
She was
what we
charged
say
with
and what the trial
perjury
court
and
found
pleaded
was
guilty
the
to
area of
perjury in
what this
December
court is to consider,
2025.
and whether it was something far more egregious. And even
along with
beyond that,
obstruction of
even
justice
beyond that,
and
even if you
misconduct.
take some of what Juror Z said, even if you take some of what Ms.
So,
Becky said, even if you
yeah.
take some of what Ms. Rhonda said, when you do that analysis and you put it in the entire context of thing, and when you put it in the entire context of this entire trial, and you put it in the context of where it occurred and everything that went on after that point, then the state has overthrown prejudice. And as Justice Hull said, she finds it, she did not find that a few foolish and fleeting comments in the entirety of this trial would be enough to have infected this verdict and to make it unfair. I completely agree that somebody's entitled to all 12 jurors, but this is a credibility finding that 11 told the truth and 1 did not, and the 11 set the
So what
standard
about when one of
of
your
what
jurors
this
is a
court should
liar?
consider,
You
and those
entitled
comments
to
were not egregious.
12 credible jurors?
Please, yes, sir, Justice James. And we may have some other questions as well. Just
I've
one
got-
second,
I've
please,
got-
Ms. Porter.
A few. You go ahead.
No, you go ahead.
The jury of 11 versus 12. In the defendant's brief, he argues that Judge Toll studiously avoided Parker versus Gladden.
Mhm.
And I think that's the case where it took a vote of 10 out of 12 to find somebody guilty.
Correct.
There is no mention of Parker versus Gladden in this order. Is that still good law?
Yes, sir. And I'm not
Okay,
contending
so,
this-
but you said several times, and I would too if I were you, that 11 jurors said, no, my verdict was my verdict.
Right.
So that takes me, I just want to, you can respond to the Parker versus Gladden part in a moment, but you also need to explain to me about the
About
egg
one
juror.
juror.
She was removed from this jury on the day deliberations began. Is that
Mhm.
correct?
Yes, sir.
So she was not an alternate. She was a sitting juror.
Correct.
And so she was there and removed minutes before they began talking about the case, began deliberating, correct?
Why was
Correct.
that?
And she said in her affidavit, that her ex-husband called her as she was getting on the bus to ride to the courthouse that morning. That upset her because she had a restraining order prohibiting him from contacting her.
Oh, no.
So she called or she spoke to Ms. Hill, correct?
Yes.
And Ms. Hill told her, according to the egg juror, the Murdochs probably got to him. You agree that's what she said in her affidavit?
That's what she said in her affidavit.
Okay.
Oh, what?
And then Ms. Hill asked her if she was leaning one way or the other. And the egg juror said, Mr. Waters' closing was good, but I still have questions.
Oh.
And she said, what kind of questions? And she told Ms. Hill she had questions about the guns. I suppose couldn't find them or there were two used. And then Ms. Hill asked her, what makes you think he's innocent? And she said, the video at the kennels. And then she said, Ms. Hill said, everything the defendant has said has been lies, and you should forget about the guns. They will never be seen again. Are those fleeting comments or are those egregious?
Oh, that's a.
Your Honor, those would be hard pressed to defend. Yes, sir.
Okay.
That would be much different from when I'm arguing this record.
And then Ms.
reflects.
Hill told her that the foreperson should just go in and ask for a raise of hands, and this will be over and done with, and everybody needs to be on the same page.
But Miss Hill got
So
it
I'm
in the
struggling,
jury.
number one, with why the egg juror wasn't allowed to testify, because that was directly impeaching of Ms. Hill's testimony that she said nothing, correct?
Yes, sir.
And Judge Toll did say that the egg juror's affidavit is in the record, so we know what she said, Ms. Hill said. So
can
can
consider
we consider that affidavit?
It's in the record. I don't know
Ultimately,
how
I
you feel.
think that Justice Toll, when she made her ruling on, and again, within the discretion of the trial court, as the case law allows her to do, to set the tenor of this inquiry, was only looking
She
at
should have testified.
the jurors who actually deliberated. And I think ultimately we got to the alternate because the alternate was there to the end. The difference with the egg lady, and we have to remember this
I
too
think
when we
it's
look
egg
at
lady because
the
apparently she was talking
implicit
about the case
rejection of all
outside
of
of the.
that, is
jury
that
room.
the egg lady
It's
was,
with
and
everybody else
it
at
wasn't
the
like she
table.
just got kicked off that morning. That was the product of a couple of days of in-camera hearings that ultimately disclosed that this egg lady juror, who initially said she had not talked about the case, it was ultimately discovered that she had. And all of this stuff about, the Facebook and all that other stuff, Judge Newman was very clear was not the basis for
Distinguish
her
that
removal.
from
It was the basis for her removal
jury
was her
talking
violation
about Miss- with
of
Miss
the,
Hill.
When somebody delivered a refrigerator
correct.
and they said she was talking about the case.
That's correct. And then, and that was after she denied it. And then ultimately it came to pass that that was not the case. And Judge Newman removed
I
her,
love Judge
frankly,
Newman.
for that misconduct. And so that in and of itself is supported in the record as a basis in the record for Justice Toll's rejection of the credibility of all of that. And this is a person, again, who wrote a book afterwards and months of going on when all of this stuff started percolating up. I think that's all relevant to consider as well.
Wow, I cannot believe
Justice Hill.
Mr. Waters,
that-
you talked a lot about the
that
timing
he's
of this
affidavit.
case and the length of it. Now, the
Mhm.
clerk is the public official who jurors have their first contact with from the courthouse
Thing. They
and
both
their
work for.
last. She's the administrative face
Court has the
of the
same
court,
concerns I
essentially.
have.
Her name's on the letterhead of the jury summons that the jurors get. She swears in the jurors. She swears in all the witnesses as they're about to testify.
Mhm.
She coordinates the juror schedule. She's a liaison between the court and the jury. She's their guide or
Yes,
their
yes,
Sherpa, so to speak. She's their point person. And she reads the verdict and she signs their paychecks at the end of the trial.
Oh.
Justice is supposed to be blind. We all know that. But court officials, when it comes to the merits of a case, are supposed to be mute.
I'd say Creighton's getting
That's
dragged
the
through
ideal.
coals
That's
a
the
little bit here.
aspiration. Even our
Getting right-
Constitution prohibits the trial judge from commenting on the facts of the case in open court.
Wow.
Now, after a 6-week trial, it's only human nature that these jurors might become bonded to this person. So you've talked about the timing, and I'd like to talk about the source of these comments and where they occurred, which was in the jury room. So
Mm.
can you comment on that?
Yes, sir. So I absolutely hear what you're saying. I think though that maybe overstates, and I don't at all distinguish or disagree with you about what a clerk should do and the role that they serve and all the rest of that. But I do think that overstates what Justice Toll was supposed to do and what this court is supposed to review, and that is the specific circumstances that occurred here. And I think that maybe overstates Ms. Becky's sort of influence in all of this at this point in time. The jury, actually, the person who handled the jurors day to day was Bill Polk, not Miss Becky. And in fact, as Miss Rhonda testified, Miss Becky got sick, and Miss Rhonda was at the trial more than Miss Becky was. And so, while certainly some of those factors may exist, I think when you look, and
think
this is
Miss
what I argued
Becky was
before, when you
missing
look
for
at what
most
was
of the
going on in
6
this
weeks.
courthouse, when you look at the entirety of the specific facts here, when you look at Judge Newman on the stand, it was really, if you want to say the Sherpa, the shepherd of these jurors is Judge Newman, not Becky Hill. When you look at the entirety of this record, I don't think that, while you're exactly right that the clerk has that neutral role and serves those functions, that in this particular instance, Miss Becky's influence was that large, and there's no evidence of that in the record. And to go back to what Justice James was saying is, this is part of the rejection of that credibility, that all of those detailed things just
Come on,
so
Beck,
above
bring up
and
the
beyond the
point.
pale that the egg lady
Lady
says
got
happened,
kicked out.
and all of that
We just
contact.
talked about
No
this
other
case.
No other
outside the
juror
court.
said anything like that. And those were the jurors that Justice Toll found credible. And again, that has support in the record
Why
that Miss
aren't
Becky
we
has just decided
disqualifying
egg lady
all
of
the
all people is
jurors
the person
for
that
their
she's going to go
conversation
through
with
all
Becky
of this
Hill?
with and not have similar conversations or similar things like that with all of these other jurors. And again, that in and of itself is support in the record for us to put those aside and focus on what the 11 said. Not that 11's good enough, but that 11 are credible, and that rejects these claims of the others that all have credibility issues that have support.
No.
The circumstances of this issue are not lost on us. In the courtroom, we have an excellent attorney general with a very professional and competent team of prosecutors, including you, Mr. Waters. On the defense side, we have an
Attorney
extremely
General, attorney for
competent,
governor.
top drawer representation. We've got a superb trial court judge. And out in the hallway, we have a rogue clerk of court. And even if we accept the truncated version of what you characterize as innocuous statements, even you acknowledge it was improper. Perhaps not improper to the point of reversal, but you acknowledge it was improper.
Oh.
Absolutely. And if I can respond very quickly.
Well, I want to make the note, because in my position as Chief Justice, I have to deal with the clerks of courts in 46 counties. And the overwhelming majority of our clerks of court are dedicated,
Mhm.
conscientious
Yes, yes.
public servants who
Absolutely.
discharge the duties of their office with integrity
Absolutely.
and do not act like this.
I was shocked.
And I'll give you the final word.
Thank you, Chief Justice. I think what you just said highlights and proves my point when you went through all of the players in this trial and
How?
the relative insignificance of Miss Becky. And as I said before, with all that going on, that some jurors really like,
No,
oh,
no,
well,
no,
Miss
no,
Becky
no,
said
no.
watch his body language, that is going to make the difference.
Oh,
What you just
Peyton,
said
don't say
of
that.
all that
Their
went on
reports are
is why,
insignificant. They're
not the
very
truncated version,
significant.
and I understand your point with that, but what
You're going to have to be
the
enforced
record
to tell
reflects
them
and what
them.
Justice Toll found is what really happened. That was the extent of it. I don't mean to imply they were innocuous. What I mean to imply is that they were neutral on their face, not proper, but neutral on their face and not egregious.
Thank you so much. Appreciate the fine arguments on both sides. At this time, before we go to you can do the reply now on this issue? I thought we were going to do the reply at the end. What was your understanding, Mr. Barber?
Mr. Chief Justice, the reply would be at the end of the. Okay. That was my
That's mine
understanding.
too. So we'll take a, say, 10-minute break. Everybody stretch their legs, restroom
right.
break, and then we'll be back in 10 minutes. Thank you.
10-minute break. Let's pause this and fast forward over. What are you thinking so far, Dee? Questions, comments, concerns?
I don't know. I mean, I definitely think that what she did was wrong. Do I think it made a difference in the verdict? I'm not quite sure. It's just the way I feel about it.
And I think it would be hard to be quite sure given the passage of time. Yeah, I mean, just thinking on this.
Well, because we watched the trial the whole time is the reason why I say I don't think it would have made any difference if somebody said those things about Alec to me.
Here's the thing.
What-
Egg Lady was on the fence. Egg Lady gets tossed for talking about the case
Mhm.
before deliberations. Yet Becky Hill's talking to everybody about the case on the jury
Mhm.
before deliberations.
Right.
Becky Hill, who is signing their paychecks and whose name is on the letterhead and who's bringing them lunch every day. So why not disqualify the whole jury for the same thing?
My understanding is they feel like at least those 11 all consistently said it did not make a difference in their verdict. The things that she said.
And the one at the end was like, couldn't remember. It had been
Mhm.
a while. And the Egg Lady didn't get a chance because she got kicked out for having discussions outside of court, which
Mhm.
they're not going to sit there and say Judge Newman's ruling that you should only consider what was here would cure any of her outside discussions.
Mhm.
So how do we cure Becky's influence? The one time that Alec gets to testify, she says, watch him,
Mhm.
listen to his words, watch his words. What was it?
Something, yeah.
Basically,
Pay
he's
attention
a
to his
liar.
comments. Yeah. Watch
Right.
his body language, whatever.
But we're going to toss her out for talking to her refrigerator person versus somebody talking to them about the case when they're not supposed to be discussing it,
Mm-hmm.
and somebody that does seemingly have power, whose name is on the courthouse.
Right. But they
court.
tossed out a juror, not an entire trial. I think
Right.
that's
But the other jurors arguably did the same thing that juror did. Had discussions about the case outside.
with the clerk.
Right.
Mm-mm.
And had that one juror not been tossed, she might have been the hanging vote. The hung jury.
Yeah. I don't know.
We'll see. I thought they were tough on Creighton.
Mm-hmm.
But there's also parts where he's starting to let his position slip a little. He's like, I'm not saying that. Like, I kind of agree.
Mm-hmm.
He's not holding firm in his position. There were like 2 parts. I noticed that. Okay.
We move to phase 2 of the oral argument. Mr. Griffin, are you going to be arguing the evidentiary issues? We're ready to hear from you, sir. And good
All
morning.
right. I think we got Jim.
Chief Justice Kittredge, members of the court, I'm Jim Griffin. I'm here representing the appellant Alec Murdaugh. This appeal presents 5 fundamental evidentiary errors
It's
that
younger.
individually and cumulatively denied Alec Murdaugh a fair trial. First, the court admitted testimony from a cell phone forensic evidence who confessed that he had never actually done a physical experimentation like the one about which he testified and knew nothing more than anyone else in the courtroom. 2, the court admitted
Whoa. Did you hear that? The cell phone expert said that he had never done a test like the one he was testifying to. And the court
What?
still admitted that as evidence. And Jim's like, even though he had no other experience than anyone else in the courtroom because he had never done that test.
I'm going to take
Wow.
puppies out.
gunshot residue evidence from a blue raincoat, despite
Yeah.
the fact that the only connecting witness definitively testified that what she saw was a blue tarp and could not be confused with a rain jacket. 3, the trial court admitted unfairly prejudicial evidence over 6 days regarding financial crimes spanning 6 years,
I knew that was going to
crimes that were committed
financial
by the
crimes.
appellants. 4, the prosecution violated Doyle v. Ohio by repeatedly impeaching Mr. Murdaugh regarding his post-Miranda silence after being arrested on the murder charges.
Ooh.
And 5, the court admitted firearms identification testimony based upon unprecedented methodology that the expert himself could not state to any reasonable degree of certainty during the counsel hearing. And
That's interesting. They're saying that they commented on Alex post Miranda silence to show he's guilty. Which a big no, but he said happened like 6 times. I knew that they were going to bring up the financial crimes. I actually, indeed, just wanted to take the dogs out. I actually talked to her about that. I said, that's going to come up.
interest of time on that 5th issue, I intend to rely on the briefs unless the court has any questions about that.
So
about
both
that
parties have
evidence.
submitted their arguments.
The evidence in this case did not conclusively prove defendant's guilt such that no other
He's saying he's
rational
just gonna rely
conclusion
on
could
his
be
argument
reached.
case.
Therefore, none of these errors were harmless beyond a reasonable doubt. There were no eyewitnesses to Maggie and Paul's murders. The murder weapons were never found. The forensic evidence does not support Alec's guilt. All crime scene criminologists, experts testified that whoever shot and killed Paul shot him in the head, his brains hit the ceiling, and
Oh.
blood and brain matter would have been on the guns and on the shooter. That was without a doubt. And there was no brain or blood matter found on Alec's person, his clothes, inside his Suburban, inside his home. They checked the bathtubs, nowhere. There were trace amounts of DNA found on Alec's clothing that were consistent with his explanation that he checked them for signs of life. There was minimal GSR, gunshot residue on Alex, which also was consistent by the SLED's own testimony, consistent with him going back to the house, getting a shotgun for personal protection and waiting for law enforcement to arrive. Alec Murdaugh's interactions with others after he left the kennels that night and before he returned and called 911 was normal. He talked to his son Buster. He talked to his brother John Marvin. He talked to another lawyer, Chris Wilson, about the case. They all said his demeanor was normal. Visiting his mother, there was nothing out of the ordinary about his demeanor. There's no time of death established. The coroner did a finger test under the armpit. The state relies exclusively on cell phone data inside the phone to establish a time of death, which was unreliable in our opinion. The cell phone data showed at 8:45 p.m. there's a kennel video. And Alec had lied about previously in his interviews about being at the kennel with his family. But there's a kennel video at 8:45, but there's nothing on the video that would lead someone to believe that there's a murder about to happen. It portrays a normal family. At 8:49, Paul used his phone for the last time. It had very little battery left on it. At 8:55, there was some action on Maggie's phone. And at 9:06, Maggie's phone registered movement for the last time, some 20 minutes after Alec testified that he left the kennel. We submitted expert on acoustical testing, and it was uncontradicted that if you're in the house with the door closed and the TV on, air conditioner on, you could not
It's
hear gunshots
amazing.
down at the kennel. And then Alec's testimony
6
himself
weeks
denied
of
killing his wife and
testimony.
son. So this
Getting wrapped
was
up
not
here
an
in
overwhelming
20.
evidence case. This was a very close case. And the cell phone and GPS data frankly
Circumstantial
pointed to his
evidence.
innocence,
It was
not his guilt,
forensic
as
evidence.
as I will
leading into
explain in a
the
moment. And that
sex
brings me
tape
to the first
claim.
issue that I'd like to address is that the state was allowed to present expert opinion testimony about a test that was done during the middle of trial from a cell phone forensic expert, a deputy from Charleston, who had previously been
trial.
testified about chain of custody and other issues, that during the weekend after
So
our
they
expert testified,
received
and it's
that?
critical to know that
Or was that a
Maggie's
Brady
phone was found on the
violation?
side of the road about a quarter of a mile down Moselle
Could have
Road,
objected to
at
that coming in
15
for
feet off the side of the
because they
road.
wouldn't have had a chance to have
And
their expert.
When we finally got the GPS data during trial
run the test.
from General Motors and the OnStar data, Alec went by that location doing 42 miles an hour at 9:08 p.m. As I mentioned earlier, Maggie's last phone
42 is not that fast
activity,
on those
when
back roads.
orientation changing the phone was at 9:06.
When you're out in
The
the
question
open and
is, if
there's
Alec had
nobody
thrown the
around,
phone out at 9:08, would it
42
have registered an orientation change? Would
Out
would
in
there
the
have been
middle of nowhere.
anything in the phone to record him tossing the phone out? And the testimony that the defense presented was Mika Sturgis talked about the rise to weight feature. He did an in-court demonstration. I was gonna bring my phone up here, but if you lift it up, it lights up. All of us have.
What's your theory as to when the phone was tossed
phone
out of
just
the
lit up.
window of by someone? What does the timeline show? I take it your argument is that when you toss the phone, at some point, it's going to, the raise to wake feature will activate. So my question is, on the timeline that we have, and it's extensive,
Right.
what is your theory as to when the phone was tossed?
So Justice James, with all due respect, I want to rephrase it. I think that's asking the wrong question.
Okay.
I think the right question is,
Oh.
would the phone turn on and record any sort of activity if Alec threw it out the window at 9:08?
Yeah, I know you say that, but I'm talking about in the timeline that
think
we
that's
have
a
in the
different
cell phone
question.
extractions that we do have. When was the phone tossed?
Well, I mean, the state's,
State has proven.
so you could say one explanation, it was tossed at 9:06 because that's when it registered. Or you could say at 9:06, it was down at the kennel. We don't know. Honestly, we don't know. We don't know how it got put on the side of the road. There's no witnesses. But what's so critical to our defense is that at 9:08, when Alec Murdaugh goes by that exact same spot at 42 miles an hour, if he had thrown the phone out the window, what would have happened? And the state says they were just replying to our expert, Mika Sturgis, who said he's not qualified to say whether the light would come on or not, whether it would register anything.
Similar question. I don't think you have to have a theory. That's the state's burden. But when we're looking at your argument that Alec didn't throw the phone out when he drove by because it didn't light up, that raises the question of how it got there. Somebody put it there.
Without no
And,
doubt.
and it did, and it never lit up. So the point that you're making is it's wrong for the state to be able to prove that it might not light up. But to me, it looks like it definitely didn't light up because whoever put it there, unless it was at 9:06, the phone did not light up. So I'm raising the question of whether this even makes any difference.
Well, it makes tremendous difference because if Alec threw the phone out at
But if it
at
doesn't
9:08, when he goes by that location,
when it's thrown out, then it could
our
be
evidence,
thrown out
not
at
through our
10 o'clock at
cell
night.
phone forensic person, but through our accident reconstruction acoustical guy, Mike Sutton, with Accident Reconstruction Institute in Raleigh, North Carolina, says that phone at 42 miles an hour will tumble. And when it tumbles, that raised to wake feature. So we did put in the evidence through 2 witnesses, both qualified, about what they testified.
I got that, but let's just hypothesize that Alec didn't do it. He didn't have the phone in his hand when he rode by at 9:08.
And someone
Somebody
else
came
stirred
along at
out.
9:20, these roving marauders, you call them or whatever, and they killed the Maggie and Paul. And then they were responsible for getting the phone to where it ended up. Wouldn't the phone have lit up then?
It depends on how it was
Well,
placed there.
if we don't know whether it would have lit up then, we also don't know whether it would have lit up at 9:08.
Correct.
Well, here's
That's
what,
why I'm asking why
It's
this even
gonna
makes
light
any
up or
difference.
not light up. It
here's
doesn't
what
make
we
a
know at
difference.
9:08. Alec car is going by that spot at 42 miles an hour. Did the marauders go by and pull over?
Maybe.
Were they walking? I mean, we don't know. There is no
But at
evidence in the
9:08,
record.
Maggie
What there
could've
is
been
evidence in
standing
the
at the
record is he
kennel
went by that spot
holding phone
at
up.
42 miles an hour, didn't slow down, didn't speed up. And if he had
Jim's
tossed the
mentioned it.
phone out, it would have tumbled.
The
And
judge is
all it
right.
has to do
It
is
doesn't
go
matter.
upright and the rise to wake feature would come on. And so what,
But-
to combat that, they had a guy sit around the
The
weekend
state
throwing a
said
phone around his
authorized
office
weight
from
feature
Friday
You
to
didn't
Saturday.
cross-examined
necessarily
him
have to
very
come on.
thoroughly.
So
And
that means that it could have
said,
been
you know,
tossed.
he said he
and
recorded nothing about his experiment. He
there's-
wasn't an engineer.
There was no rise to
Um,
weight.
He
when it was
didn't
tossed.
know
It
more
could've
than
been
anybody
9:08,
else,
could've
and
been
he didn't
9:20.
testify to anything you couldn't look up
I
on
agree.
Google. So
It doesn't
how,
matter. If they were
what's
saying
the
that
harm in that? I mean, your
it didn't have to light
cross-examination
up,
seemed to be
then-
very effective.
Well, the harm is the expert opinion he was allowed to express that says it was possible that the phone would not illuminate if thrown from a vehicle going 42 miles an hour. The harm
Well,
was
if
when
the phone would not
Mr.
illuminate,
Waters gets
then
up in
maybe
his
it was
closing
thrown going
argument and
42
says,
miles
Paul
an hour
Manigault got
20
up here and
minutes after
testified
Alex
as to the
left.
issues and to the fact that there's no guarantee,
Yeah.
more like,
You
in
see what I'm
fact, more
saying,
likely
Dee?
than not, if the phone is violently thrown or flipped out or whatever, it's going to light up. I mean, that was critical to their defense to address, you know, our exculpatory evidence that we went by there at 42 miles an hour. And if we had tossed the phone out, it would have shown something. If they wanted to test that, they needed to put an expert in a car doing 42 miles an hour, throwing it out the window, and then checking the phone to see what happens and do it multiple times. But you don't sit around an office as if you're playing cornhole with a beanbag all weekend and then
Why
come to
not?
court and say, sometimes it lights up and sometimes it doesn't light up. And therefore, I conclude that
So
you
they
know,
were
it's
trying
more
to
likely
use
than
it
not, it
lighting
wouldn't
up
have
at
lit up
9:06
if
as
Alec
being
Murdoch went by there
late.
at 42 miles an hour.
This is certainly an unconventional moment at the trial. And, you know, I was reflecting back on 10 years of trying cases, none of which were 6 weeks long. And, you know, in the state's reply, everybody's tired. Everybody's ready for the case to go to jury. It's almost like there's this unwritten rule of evidence that at that point in the trial, you can pretty much do whatever you want. But the question is, what did they do? And you're saying when they stood up to speak to Judge Newman, they said, we got an expert. In their brief, they talk about it simply being an experiment. Judge Newman listens to all this and he calls it an experiment. He doesn't call it expert testimony. He says, page 6721, he did not provide scientific testimony. He conducted an experiment and told the jury about it. And I'm just wondering, do we really need to go through a 702 analysis here, or should we be talking about the
No.
admissibility of an experiment?
Well, I believe this court's opinion in State v. White in 2009 that Justice Kittredge wrote, there's no distinction between, so it's an opinion testimony.
Well, that was an opinion. That was an opinion based on the work of a drug dog.
702
right.
it,
So, and here
expert.
we have an opinion testimony that when Alec Murdoch goes by that location at 42 miles an hour, it's the light may come on, may not come on. More likely that it won't come on. So that's the opinion testimony. And that is whether it's scientific or experience, it doesn't matter under the analysis, but it had to be proven to be reliable and it wasn't. The
Mr.
next issue-
Griffin, I'd like for you to address the 404B issue, if you don't mind.
Yes, sir.
Do you believe any of the evidence about the defendant's financial crimes could have been
you this was
admitted
gonna come
under
in.
404B as motive evidence.
That's what you
No,
said.
not
That's
a
what
bit,
you
Your
said,
Honor, not
Dean.
as motive
Motive.
evidence.
I said
And
character.
I have some questions, I'm sure we all
Which is
do, for
404B.
Mr. Waters in terms of the expanse that was allowed under 404B. But what about like Ms. Seckinger's testimony, for example, on the day of the discovery of the theft of the Ferris fees? What about the impending motion to compel hearing in the so-called boat case a few days later that would have arguably exposed the extent of his financial misdeeds? Why wouldn't that have some relevance for 404B motive purposes?
Well, we have the benefit of extensive in-camera hearing, well, not in-camera, but hearing outside the presence of the jury, and where all of these matters were testified to. And Ms. Seckinger said that on June 7th, she went to confront Alec about, this Ferris fee. Now, understand this Ferris fee is a one-off situation from all his other scams and schemes. This was attorney's fees that were due to the law firm that he diverted to himself. That's the Ferris fee. And that's what was their concern. And her testimony was they weren't concerned that he was stealing money from the firm. They were concerned that he was hiding money from civil discovery from the boating case. And
So under 404, you cannot use character evidence to prove that somebody does criminal acts. So
they didn't want
they're
any part of
still
that.
doing
She also
criminal
says
acts.
when she's in there talking to him, he gets a
It can be
phone
used
call.
for
They put his
motive,
dad back in the
identity, or the
hospital,
existence of
and
a
I
common
took
scheme or
my
plan. So
my
the judge
CFO
asked
hat
about
on, and I put my
motive.
friend
I
hat
don't know
on,
why
my
Jim
mama
is
hat
going
on,
over
and I started
to
comforting him, and that was the end of it.
the
So
common
until
scheme or plan.
the
He's
moment of
saying
the
that
call about the
this wasn't part
impending
of the
declining health of the father,
scheme.
we're in the motive territory.
um,
But once the
financial
urgency was
scheme.
removed by that
That's
phone
not
call,
motive.
it somehow was off the table?
I still don't think it's motive because what the cases cited by the state and any case that you look to for motive, it has to,
There we
and
go.
the cases that admit these type evidence in a murder case is that the person murdered is either the victim, the person murdered is a threat to report the crime, the person murdered has life insurance, or the murderer is bound to benefit financially to get himself or herself out of the financial hole. I mean, none of those typical motive issues are present. What was present is this claim of sympathy, which in West Virginia v.
Okay, so I believe Maggie had assets that would have gone through probate, even in the absence of life insurance. Paul, though, well, yeah. No assets, no life insurance. They were talking about this lawsuit, but just because something happens to him doesn't make the lawsuit go away. And if the lawsuit is against Paul, then it's not against the parents.
Well, they would have
Essentially,
been the
that
ones
lawsuit
paying it, though.
continued against Parker's that was just settled, I think for $15 million for Mallory Beach for Parker's over serving. I don't see how that impacts Alec. I don't know.
Well, from the financial side, I always thought Paul was because of the drugs.
What do you mean?
Because he had didn't he have like a discussion with his dad, or he had discovered his dad had started doing them again or something? Or was that Maggie?
It might have been Paul. But who is he going to tell?
I think of his mom. I can't remember. It's been too
Well, he's
long.
going to tell mom anyway. So
Probably.
I don't know. I don't know. It didn't make sense for motive.
McGinnis, and that really is the closest case that we can find about this, Your Honor. I mean, they reversed a murder conviction for letting it.
Also, assets that would have just been in Maggie's name had Alec been sued for stealing all that client money, which was horrible,
Mm-hmm.
her assets wouldn't be available to his creditors. South Carolina, we're not a community property state.
I don't
They
know.
were actually
Motive.
safer in her name.
Yeah. I always thought the motive was kind of hard to find with the case.
Right. And that is where Jim is going. This is what they're asking. Can you use it to prove motive? But it never made sense to me as far as motive.
Extensive financial crime evidence and other information in. And I would read to your honor the conclusion from the court in the West Virginia Supreme Court. It says, the cumulative admission of the evidence under 404B, however, presents us with a likelihood that the jury convicted the defendant because of his character and not because of the evidence surrounding the murder. In these circumstances, these errors cannot be regarded as harmless.
In other words, it wasn't his motive, it's his character. He was so drugged out of his mind that he's stealing from clients. He doesn't care what he does, which would be
Mhm.
character, not motive. Motive would be he's going to the police with this, so I'm going to kill him.
Mhm.
Or if I kill her, there's a financial gain. Yeah, I expected this to come up, and I'm going to play this back a little bit faster since we're behind on it.
And you can't just piecemeal it either. I mean, we spent 10 witnesses over 6 days, 38 transactions.
Was there any 404B evidence that was proffered by the state that was disallowed?
No, Your Honor, not that I can recall. And then, so you have 404.
All of the character evidence that the state put into evidence was omitted. He can't think of anything that was disallowed.
Wow.
B analysis, and you have 403, and really the unfair
Right, so
prejudice.
403, this is what I was saying, more probative than prejudicial, more prejudicial than probative. In other words, the prejudice that would have, it would have tainted the view of Alex. So it would have been more prejudicial than probative of whether or not he killed Maggie and Paul. It's a great objection to toss on to the end.
Mhm.
All these have to be raised at trial, though. So these were all set on the trial record. You can't bring it up in appeal unless it's raised at trial for a lot of objections.
Just by the weight and the extent of that evidence.
Things like subject matter jurisdiction, though, can never be waived. But anyway,
The
that's not an issue here. I digress.
sheer volume, 38 transactions, $9.97 million, 10 separate witnesses. In State v. James, I know it's a little different because State v. James involved prior burglary convictions with an enhancement, but the conviction was reversed where 7 burglary convictions were admitted when they only required 2, and there were limiting instructions given, and the court said that it was not harmless error when you pile on that much, and this was piling on.
Let me ask you a question about the legal
So in
points
that
of whether
case, there were 7 prior burglary convictions. I guess they were trying to say motive. And the court said that was too much. That was piling on. And this is what Jim's saying. Like, let's say it even does do motive, but this is more prejudicial. This is just piling on, adding
Mhm.
all this other bad stuff he did. Because there were weeks of testimony about the finances. Weeks.
Mhm.
there's a logical connection or some logical relevancy, using the language our cases have used. I mean, you make a lot of good arguments that it makes no sense. Like this, he would never have done it for this reason. And obviously those arguments are in part, at least, for the jury to iron out, right? I mean, you made them to the jury and
True.
they decide whether this makes sense in terms of a motive. But what I'm asking is, to what extent does the trial judge, when looking at a theory of motive that isn't 100% solid, to what extent does the trial judge analyze the believability, the ultimate usefulness of the theory of motive before admitting the evidence? Just to continue a second, in Lyle, we said that the trial judge has to clearly perceive the connection.
Right.
In Perry, we of course quoted that, but we also talked about the trial judge using a rigid scrutiny. I mean, really, in Lyle and Perry, though, the question was not the existence of a logical connection, because in Perry there clearly was one. I mean, in Lyle there clearly was one. in Perry, there clearly was not one, at least the majority said so. But in both cases, the real question was unfair prejudice. And I'm just wondering if this idea,
So they're talking about two different cases. In one case, there was a logical connection between the evidence and I guess the motive. In the other, there wasn't a logical connection. And the issue was the prejudice. So he's asking how much of a gatekeeper role does the judge play here, since it's up to the jury to decide whether or not that's motive? I mean, I guess one argument is that they don't have to prove motive. So,
Mm-hmm.
well, I don't think so.
Well, I mean, didn't they also need the financial stuff in order to bring in some of the witnesses, like the people he had represented that they had put on the stand? Would they have been able to bring those witnesses in without the financial stuff?
For what purpose?
Character.
But they can't bring it in for character. It's
I
not
know.
permitted for character. It's only permitted for motive.
Right. But they also couldn't have gotten the witnesses, the ones he had scammed out of the money, without the financials, right?
Right. But they shouldn't have been presenting it for character. They were put on the stand to show why he killed his wife,
Mm-hmm.
which is,
Mm-hmm.
and this is what the judge is asking. Like, what does the judge have to consider before deciding that it's more prejudicial than probative? So let's see what he says.
that the motive theory doesn't work is really a question of unfair prejudice as opposed to a question of logical relevancy.
Well, it's both. You have to do both analysis. Chief Justice Kittredge asked me if it was motive evidence. I don't believe it is motive evidence. It's certainly unfairly prejudicial under 403. And I was, to answer your question, Justice Few, I was about to cite to Lyle, the standard in Lyle, which is a very high standard. And what you have, and I think it should require, and I believe the law makes it require, more than a prosecutor's best theory. I mean, there has to be some evidence to support it. And it has to be like life insurance policy, a windfall, things of that nature.
Or I hate to use this example, but perhaps this looming cloud, storm cloud, so forth, would have given him motive to do harm to someone who was going to blow the whistle instead of,
That's right.
But there
according
was
to you,
no
too many
evidence
degrees
saying
of
he was
separation
gonna
of murdering his
blow
wife
the
and child.
whistle.
Well, if there was evidence of that, and that's in the case law, yeah, if there were a threat to
There you
report it, for
go.
sure. But none of that exists.
Yeah.
Was there
prove
any
that.
evidence that Maggie was getting wind of these financial misdeeds? She did have a bounce check or two, right?
I believe she perhaps
I mean, was there any evidence that she
Yes.
was going to confront him about money?
None whatsoever. None whatsoever.
And Paul, who's described as the detective, was there any evidence that he had any information about his financial misdeeds as opposed to him holding pills?
No, Your Honor. It was only his drug use Paul was aware of.
I want to branch off for a moment. On page 6,340 of the record, Mr. Waters was cross-examining Mr. Murdoch. And if you read it, it is very, very compelling cross-examination. Of course, Mr. Murdoch's on the stand, so his credibility is in question. Let's assume that this financial crimes evidence came in reply.
Right.
Because a series of questions that Mr. Waters asked Mr. Murdoch was, you lie, basically suggesting he lies with ease.
Correct.
Seamlessly lies about everything. Did you lie to your brothers? Did you lie to their wives? Did you lie to Marion Proctor? Did you lie to Bart Proctor? And all these answers were yes. Did you lie to the Brandstetters? Did you lie to Chris Wilson? Did you lie to them about the kennels? Did you lie to Mark Ball? So when his credibility comes into question, then
Right.
could this financial evidence have come in reply? I know that's not what we have here, but
Right.
Doesn't it
More
kind of open the door?
prejudicial
Or
than
maybe
probative. You
you
don't
would
need
have
to
chosen not to put him on the
dogpile.
stand had the financial stuff
I
not
think
come in
they've made
initially.
their
Whether-
point before that.
2 points with that. One, I don't think we cite a case law that we don't waive our right to challenge that by putting him on the stand
I
to
get
address
that.
it.
I get that.
But to answer your question specifically, under 608B, Your Honor, you are not permitted to put in extrinsic evidence of these things. You can ask him about it, but you can't then take 6 days and 10 witnesses. I mean, you ask him the question, and if he answers it,
Good point.
you got it. If he denies it, you're stuck with it. That's why under 608B, you're allowed to cross-examine him, but you're not allowed to introduce extrinsic evidence.
What if the questions had been more expansive? Did you lie to your partners about not stealing $9.7 million? I mean, it becomes, it's a different dynamic, I understand, but what I'm trying to search for is, would this
But
have
you've
come in
proven
anyway?
he's a
Well,
liar without
I do
all.
believe under 608, it's fair ground for cross-examination on his credibility. But then you get to
Stuck
403
with his
analysis.
answer.
Excuse me?
You're stuck with his answer, which would have been
Right.
yes.
Yeah, but you don't get to then start putting up 10 witnesses to prove something that he's admitted to.
You get a new trial is coming in, but it's only, at least under 608,
If he testifies.
if he testifies. And in that event, you get another limiting instruction that says you can only use this to analyze his credibility.
Thank you.
Oh, wait a minute, we're just getting started.
We we have a question. We want you to argue about the admissibility of the weapons that were seized and introduced that were from Mizell.
Yeah, so, in the weapons that were introduced in the evidence that were seized from the home, there was no, testimony from anybody, even their,
Goes beyond that. The experts admitted that he could not identify it as a murder weapon.
well, he said he couldn't include them or exclude them. And so, as we said, these guns, we know nothing more about them today than we did, any other day. Yet they were allowed to put those in the evidence. And we've got State v. McConnell and another case where I think McConnell, where they put 22 caliber bullets in evidence on a shooting case. And the person was shot and killed with .357 Magnum. And that case was reversed. There was another case that we also cited, lost my place in my notes, but that.
What was the purpose, as you understand it, for the admission of the weapons that were seized from Mizell?
To prejudice Alec Murdaugh. I mean, that was the purpose. It made nothing more relevant or not relevant. I mean,
Didn't you suggest, though, that the police who investigated this had failed to do a complete job, and in particular, that they had failed to properly seek out and find the murder weapons?
absolutely. And that
And
stands
wouldn't
true today.
simply, wouldn't a simple response to that suggestion be, we looked at every 12 gauge and 300 blackout weapon on property and here for them?
Here's pictures of 4 of them, but you don't put them in evidence. You can have Greer testify, I tested all these guns. I don't know anything more about them today than I did yesterday. I can't include them or exclude them. That testimony is perfectly appropriate. But
After they were put into evidence, were they ever used or referenced again, touched again?
absolutely, the Attorney General picks it up, holds it up, pretends that he's shooting somebody. He picks up the 300 blackout and reenacts the crime. They're
Dick Harpootlian
Mr. Kinsey used them?
created
They
the
can be used for demonstrative purposes. You just object to them going
The
back to the
gun.
jury room. Is that what you're saying?
We did object to them going into evidence for sure. And they could have had a demonstrative, they could have had a demonstrative exhibit to demonstrate to the jury, but that's not what these were. These went into the jury and they did an in-court reenactment with them.
Mr. Griffin, I interrupted you a little while ago to segue to the 404B issue, and I think you were either at or near the conclusion of your argument regarding the cell phone experiment.
Right.
And if I cut you off, I didn't mean to, and I want to give you an opportunity if you want to finish any thoughts you had on that issue. It seemed very important to you, and I want to give you that opportunity.
I was done with the cell phone. I was going to go to the blue tarp and then the Dole v. Ohio issues, but I'll rely upon the briefs and Mr. Barber may be able to address it. But I'm happy to stand up here and answer any questions about those issues.
We have a question.
Help me out here. The evidence was Mr. Murdoch didn't use his phone from 8:09 to 8:40 something, 8:50, maybe 9 o'clock, right?
Right.
Which was unusual for him, according to the evidence. What does it mean in the testimony of the cell phone extraction witness when a call was in the Verizon records, but not on Mr. Murdoch's extraction? What does that mean? It's there's a series. I made a series of notes. This
I
call
mean, he
was
deleted the call
not on his extraction. It was on Maggie Murdoch's
that
extraction, but not his.
through his phone because he deleted it.
905 calls Randolph, not on extraction. Does that mean that the inference is that he physically deleted it on his phone?
I believe so.
And there were probably 10 or 12 or more phone calls that were deleted, if
Right.
that's what the explanation is about not on his extraction.
I believe that is the case, that the information was deleted from his phone for some reason or another.
And this goes to circumstantial evidence of something,
Oopsie.
that he deleted the call. Was there any explanation at trial from your side, not that you were required to give one, as to why those calls weren't on his extraction?
There's no testimony about that at trial.
Okay, all right.
I have thoughts about that, but it's not in the record.
All right.
Justice Hill has a question.
Maggie's phone did not record steps at the
Right.
time, and you make a point about that.
Yep.
But also the location data got overridden. Did that override the step data too?
That did not override the step data.
Okay.
And that was maintained in a different place, but the GPS data is pinging constantly and there's only so much room, and SLED did not put that phone in a Faraday bag, which I didn't know what a Faraday bag was before this case, but they give them away at conferences. So it's not unique.
Thank you.
All right, no further questions.
Thank
Thank you so much, Mr. Griffin. Appreciate it. Yes, sir, Mr. Waters.
Thank
Oh,
you, Chief Justice, and may it
you
please the
doing
court.
it all.
I'll start out by saying, and again, I'm not going to, unless this court would like me to go through the extensive facts that were presented here. But fundamentally, our case boiled down to 4 important points. Number 1 was motive, and I know we'll talk about that. And I believe that the motive was very compelling here, and we'll go into that. But motive pointed to Alec Murdaugh. Number 2 was the means to commit this crime. And what the evidence showed were 2 family weapons were used to commit this crime, both of which
What a means
could not be
and
accounted for after
opportunity.
the crime was over with. Number three, opportunity. And this was huge. That timeline that was very detailed, that frankly the defendant tried to use to be exculpatory, actually was very inculpatory, and showed that not only was he at the crime scene with the victims just moments before they died, but
Circumstances,
importantly had been lying about that to anyone who would listen.
opportunity.
And that evidence was particularly strong when you look at the fact that when we look at that kind of evidence, we look at patterns. And what was also so important about him being there is that his phone showed no activity, as Justice James mentioned, from about 8:09 to 9:02. And then from 9:02 to 9:04, he had 283 steps, far, far more than he ever had in any comparable period during the review period that we had. So you had that evidence of opportunity showing that he was the one who had the opportunity to commit these crimes. And then finally, you had multiple acts of guilty consciousness and various things that he told law enforcement and all the rest of it. So that's a classic case. It may have been a long case and put it all together, but it boils down to basic, good old, how do you determine who did somebody? Motive, means, opportunity, and acts of guilty consciousness. And I think the evidence was very strong with all of that. We started with the cell phone evidence, and I'll go to that as well, since that's what counsel started with. And I want to start out by saying, first of all, that this is clearly not preserved. I'm going to talk about that very briefly because, as Chief Justice Kittredge pointed out earlier, this was an old school judge. You got old school lawyers, old school prosecutors, and Judge Newman made it very clear at the beginning of this case what he expected with objections, that they be timely and that they be specific. Okay, so this is not a case where preservation is a gotcha moment. This is a case where the judge was very clear about what he expected with that, and the parties that were trying this case are ones who understood that very well. So I think if there's ever a case to look at error preservation issues we've raised throughout this brief, this is that case to do that. But beyond that, let's look at what happened during the defense case. They called an expert who, Mr. Surgis, who's a former North Carolina deputy who has digital forensic examiner training in Cellbrite and Apple, and he was qualified in cell phone forensics. And while he was on the stand, he used an unidentified iPhone with an unidentified iOS operating system to demonstrate for the jury that just a general motion will cause the raise to wake feature to turn on. And they emphasized that over and over again, that all it took was a gentle motion. Just a gentle motion is all it took. And they did that demonstration on the stand. And so the state, in reply, called a deputy who had extensive training in digital forensic examination, same exact training, who was qualified without objection in the same exact cell phone forensics. And what was more important here was he was here to correct fundamentally what was a misleading statement from the defense examiner, because what he knows, and he knows how these things are programmed, he knows how they work. And the implication that if only a general movement will turn it on, that necessarily a more violent one, like slinging it like a frisbee, will turn it on, is false, because the phones are designed and programmed, the accelerometer in there are programmed, so that while a general normal motion when somebody wants to look at their phone will trigger it, violent motion will not, so that your phone's not constantly coming on when you're jogging or running or doing anything like that. People don't look at their phone like that, okay? And so the phones are designed to do that. So he did the exact same thing that the defense examiner did, except for he did it much better, because first of all, he used the exact same model iPhone, he used a similar iOS version that was used, and he manipulated it multiple times in many different categories. And it was there to ultimately disabuse the notion that if it comes on gently, it necessarily is going to come on when you sling it, because it just doesn't. And that is how iPhones work. And so when he was in cross-examination, and Mr. Griffin did a great job of cross-examining him, and at one point he says, well, I don't know anything about anybody else. Well, maybe that was an inopportune answer, but that's not the end of it, because he went on after that to testify, I have expertise in how cell phones work. I can tell you about the knowledge sheet databases. I can tell you the ways iPhones, the software is written, what kind of code is written on it. I can tell you how data is stored on it and the program that's involved in it, the programming that's involved in it. And frankly, his testimony proves the point, because he made sure that the jury understood that just because a gentle raised awake, a general motion will trigger the raised awake, doesn't mean that a violent
trying to
motion will
say
do that.
that
In fact, it's
his
more likely that it won't.
witness
Phones are
was an
designed specifically to do
expert,
that. That is
and
an expertise that is beyond the knowledge of the average
Judge
person.
Lawrence
And again, this is
testifies
not one, I think, as we talk about
Again,
before,
I-
we need to apply the
agree
counsel
with the
factors and all the
court
rest of it.
here. I don't
When you're
think
talking
it
about sort of
matters.
experiential type of testimony, the ultimate test is reliability. And he had the same exact qualifications, the same background, and was qualified in the same manner.
But his testimony was sometimes it does, sometimes it doesn't.
That's correct. And that's the reality of how it works. Because again, these things are programmed to react to different types of inputs. And it's not an absolute guarantee. But the point that was important about that
Sometimes
was
does,
that
sometimes
just because
doesn't.
a gentle motion might turn it on doesn't mean that a violent one would. In fact, it's more likely that it won't, because the phone's programmed to do that, like throwing it like a frisbee.
This is probably not relevant to much, but why this phone being taken from the scene, and why not Paul's? Why not just leave hers there too?
Well, that's very interesting.
Was there any, I know, is there evidence? I think there's evidence that it was raised to wake at some point and put back down.
Yes.
So that was at 9:02, 9:04, something like that?
Correct. So the evidence, if you look at that timeline, and I could go into it in great detail, but what the evidence showed and what the reasonable inferences from it was, number one, Alec had Maggie's passcode. He did not have Paul's passcode.
You might need to stick closer to the mic.
I apologize. All right. So he did not have Paul's passcode. Paul's laying face down, and his phone is laying just on the outside of his rear end, outside of his pocket. And in fact, the defendant told police that he picked up the phone, or he tried to turn Paul over, and the phone just popped out. Okay. But what's interesting about that is what's so crucial about the time of death and the forensic timeline, as we call it, establishing that time of death, is that Paul was actively in a conversation with his buddy Rogan Gibson, and that's who the kennel video was for. But he never completed that conversation, and both Paul and Maggie's phone go silent forever and ever, amen, at 8:49, about 30 seconds. Well, Rogan continues to try to contact Paul. All right. And so when we look at contact on Paul's phone, there's somebody who actually looked at it, and the backlight came on, which is indicative of somebody, the Face ID not recognizing who it was. But as we know, those phones will display like messages coming in. And very interestingly, Alec Murdoch, in the wake of the brutal murders of his wife and son, he calls his brother, but then before he starts calling all these other family members, he's blowing up Rogan Gibson's phone. Okay. So the inference is that he saw that, he can't get into Paul's phone, but he's concerned about Rogan. The other inference is that he takes Maggie's phone with him, because we see steps on her phone, and we also see activity of the orientation changing. And that orientation will only be logged if the backlight is on. And so when he gets to back to the house, that's all of a sudden when his phone comes alive. From 9:02 to 9:06, there are 283 steps, but at the same time, we're seeing orientation changes and he is calling Maggie's phone. In fact, we can see an orientation change 2 seconds before the call comes in, which is certainly susceptible to the inference that whoever's calling is looking to see that call come in, like somebody who's manufacturing an alibi, like somebody who tells the police in his first interview, look at my phone, I was calling Maggie. He calls her multiple times while he is running around like a chicken with his head cut off and then jumps in the car. And even though he said that Maggie came home because he asked her or she was worried about him, and Marion Proctor testified that Maggie came home to go visit Miss Libby, after all that, he's blowing up her phone. He doesn't take the 100 yards down to the kennels to drive by there. So again, not to argue the facts, but all of this was very indicative when you look at
We're
this
just
timeline of
rehashing what
Alec
happened at
looking at Paul's
trial.
phone, leaving it there, taking Maggie's
basically
phone,
he's
taking it up there,
saying-
start manufacturing, making sure those calls are coming in, and then as he's leaving out
Was
in
that
haste, is we wrote a detailed pretrial motion and laid it entirely out, wrote out every bit of it, wrote out the entire theory, and put that out for the defense and said, Judge, defense, this is what we're planning on doing. And in opening, I was very careful. I just said, there's going to be things going on in his life. I didn't talk at all about that. And then we did the in-camera hearing, and we were very careful. And before I even broached those subjects, I raised
Okay,
that to the trial judge.
they're getting
ensure
to the
that
financial.
The entirety of that was being considered.
Was there any 404B that was disallowed?
There was. So there was 404 of evidence of an affair that Marion Proctor and Maggie's concern
Oh.
about affair that he excluded as too remote. And then there was a side of the road and narcotics evidence, but ultimately that eventually came into play because of opening the door.
Was there any
So-
404B related to financial crimes that was disallowed?
Side of the road, yes.
I think
Brandon.
no, but I think that that
That's
we
what concerns me. And I want to just gently push back and give you an opportunity to respond. Yes, the judge is a gatekeeper. Unlike the federal counterpart of 404B, our case law has said that our version of 404B is a rule of exclusion, not inclusion.
Right.
And the gate here was just left open. And I couldn't find any example of financial crime evidence that
That's
was
interesting.
excluded. And
So
the granular
he's saying in state court, it's a rule of exclusion, not inclusion. It's like you exclude things. That's interesting.
detail in the expansiveness of which everything under the sun was allowed is arguably problematic. Even the nature of the victims.
I knew
There
that
are many
they
examples
concerned
here.
With this when
And
this
I want you to
trial
respond. So I'll just share one.
Mhm.
I think his name is Tony Satterfield,
Right.
was testifying. Well, we had to hear about the disabled brother.
Mhm.
How is that relate to motive evidence? That appears to be that not only is he a thief with a motive for murder,
Mm.
he's a despicable, low-life character. I mean, the very evil that 404B is designed to prevent, and then ultimately 403 as the final safeguard.
Well, first of all, I'll say that this was never argued nor presented as propensity evidence. And frankly, this court has recognized and other courts have recognized that the less likelihood of propensity when there's a vast difference between the type of 404 crime and the crime it issued. You know, once a stealing white collar lawyer, always a wife and son murderer. That's never was the inference and all the rest of it. Satterfield was independently relevant, and we streamlined this inquiry intentionally. And the defense made their general objection to the 404, but never did once we kind of crossed through that door. We presented all of that in camera, never made any specific, like, you know, limit this part, limit that part. We tried to streamline it all. The only reason Satterfield was a witness who testified specifically was because Satterfield was one of the factors in the gathering storm. Satterfield, of course, there had testified that Appellant had reached out to him and that he had reached out to Appellant in the months leading up to the murders. I think even in June of 2021, asking about the case and about the settlement. And Alec, of course, is lying to him and saying, yeah, I'm still working on the case. I'm still going. But the reality is that he stole almost $3.4 million and had spent it 2 years ago.
But what did one of the Satterfield children's status as mentally disabled have to do with any of that?
Well, I think the point of that was just sort of the background of how Alec had interacted with them and how this was a family that was close to him.
Did the fact that the young man was disabled add to the fact that he stole?
I think what it added to,
What
again, was we had a witness who was testifying for
Character.
independent purposes. And that was just a background fact of the pressures on Alec because he had taken this family under his wing, a family who had one individual that he had told, I'm going to help you. I'm going to take care of you. One
That's
of whom had special
character
needs.
evidence.
He had spent all of that money. They're
That
asking
doesn't have
questions
to do
about it.
with
The
motive.
sympathy directed toward the victims of the crime is not related to the motive. If he's a thief and that was the motive for doing it, this extraneous information that tugs at your heartstrings
Yep.
is not related to that. And like when I asked you the question earlier, you responded by immediately segueing back to the financial crime itself,
And then
not
using
this
the way back
extraneous
there.
stuff of every granular detail
Yes, sir.
of his
Not good.
acts of theft.
And I will just say, in putting that in, that was just, we had a witness testifying. That was part of the background information that witness testified to. And that, again, it was part of his interactions with this family that was part of the pressures, one of a myriad of factors that were all coming to a head in June of 2021.
If you had condensed your theory of motive,
Right.
the whole gathering storm thing, down to the essentials and left out all the stuff that
Days.
the Chief Justice and Justice James were talking about. In my view, you could have done that in about an hour and a half or 2 hours. You took 12 and a half hours to do it. And then you're taking that condensed version, you're presenting it to the judge. to try to establish a logical connection. This is following up on something Justice Verdon asked and also asked the same question of Jim Griffin.
Right.
What is the level of inquiry that the trial judge goes into to kind of get to the legitimacy
Right,
of the
so-
theory of motive? Obviously, the jury would be the ultimate decision maker on that, but
On motive.
to what extent should the trial judge question whether it's a valid and legitimate theory of motive?
Well, I think that the words of the logical connection are there. And I think that as far as the trial and the clear and convincing nature of the evidence, but I think as long as it is a passable theory of motive and that motive is logically connected to the underlying crime, then ultimately, as you say,
Well,
it's for the.
In all the cases that I think we've looked at this logical connection question, it's been either easy, yes, there's a logical connection, or easy, no, there's not one.
Right.
Here, it's not easy. It's debatable, right?
Yeah.
Your Honor, I would say, and if you'll permit me, I'll go through why these are all connected and why
right.
this is a unique situation and it demands, it's a complicated situation and I would submit demands a complicated analysis of the law. It's not the typical case where you have a one-off crime, a few hours. It's not Adams, right? Where it's an armed robbery just a couple hours before and they're smoking crack and that sort of thing. This is a long, unbroken chain. And Your Honor, you can't understand the boiling point, which was crucial to the state's motive. And I always say motive is not an element, but it's the only element. And particularly in a case like this, where it's the murder of a wife and son, it is what everyone wants to know. And there's no a disconnect between someone having a financial motive for a crime. I mean, it's in the movies, it's in Fargo, it's in
I hadn't
He's
seen
not
Fargo.
asking
Get it.
about
all right, yes, sir. All right, but I'm just saying this is in a number of movies. But let's look at why this is all interconnected. First of all, it's all interconnected, despite how temporal the temporal time period, because what's relevant to motive is what is in the appellant's mind, okay, and what he knows is potentially going to be and is about to be exposed. And that's all of it. And
But you didn't prove anything was about to be exposed. He wanted that evidence to come in for character evidence. And this isn't a big complicated issue, except that he's having trouble fitting it into being proper motive instead of improper character. That's why it's complicated.
frankly,
It's hard to understand because it probably doesn't work.
eventually was. So what is relevant is not, well, it was just yesterday or it was last week or it was a year ago. What is relevant is what does he know all is about to come out? And that's a decade of him constantly staying one step ahead of the game through one theft as another. And that brings up the second point, that this is all interconnected. It's an unbroken chain. And you can't truly understand, and what is crucial, motive, you can't truly understand the boiling point if you don't understand the slow burn leading up to that. Okay.
But do you have to go through every single part of the slow burn? Which I'm sitting here thinking, I mean, you'd have to have. At what point are you dogpiling and it's becoming more prejudicial than probative?
Mhm.
6 days of a 6-week trial?
Okay. And the defense put motive in issue as right. Their biggest thing was, frankly, character evidence of he's father of the year. There's no way he could have done this. So this, in the case law says that where motive is a central issue like that, that there is a wider scope. But let's talk about it's interconnected. The jury could not understand the full weight of the pressures if they didn't understand that entire criminal and financial history. You can't understand the need for it without understanding the lifestyle, the bad real estate deals, the maxed out loans. You can't understand the Badger theft of over $1 million if you don't understand that they had, with his bank co-conspirator, had stolen $1 million from the Plier loans, and that had to be accounted for. You can't understand the need for fake forge and why he did that if you don't understand the complications of having to steal that $1 million.
I think all of that is completely accurate.
Mhm.
The disconnect that the defense is getting at and that I'm trying to ask you about
Yes, sir.
occurs
How is that motive to
when
murder?
he takes the what the judge called some sort of urgency. He had a nice phrase he used when he was ruling on it. How do you get from that to murdering your wife and son? That's the disconnect that the defense is focused on. They're not focused on the disconnect between forge and stealing money. That everybody understands that. And my question is, when analyzing that disconnect, what's the point of law? What's the rule of law that we look at? That the trial
Stealing
judge looks at?
money to murdering your wife to get assets that are in her name and protected from your creditors, and murdering your son who doesn't have assets and whose creditors wouldn't go after you.
Well, again, I think that the trial judge makes that determination of whether there's a logical connection and whether or not the evidence is clear and convincing. And I understand that under South Carolina, there is a gatekeeping function that is there. But I think that as long as that
Let me
there's
throw out a couple of examples and I'm going to leave this alone.
Mhm.
Obviously, you think there's a logical connection. Is that enough for the trial judge? Or does the trial judge have to decide for him or herself whether there's a logical connection? Or does the trial judge have to look at whether there's a reasonable possibility that the jury might find there's a logical connection?
I would assert that the trial judge should look to whether or not that is a reasonable inference from the evidence. And if it's a reasonable inference, and then it should go to the jury. I mean, that's what we do with all sorts of evidence, is determine whether or not there's a reasonable inference from this evidence. And if so, reasonable inferences are for the jury.
Can I follow up on that?
Yes, sir.
I think Justice Few wrote State versus Perry, and it
I wrote 3/5 of it.
it helps the Forrest Gump and me understand it. This 404B evidence.
I like him.
I am also struggling with the logical connection.
I am too.
Your brief is excellent, phenomenally done, but you say in the brief on page 87 that according to Perry, relevant is defined as evidence having a tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable, so forth and so on. You emphasize the word any. And what I fear is if we get on that train and emphasize the word any, that allows speculation to enter the room. Help me out with that, because I would accept, you emphasize in your brief, boat wreck, boat wreck, boat wreck. That's all Alec Murdoch wanted to talk about when he was on video.
Right.
I get that. So I think there's clear evidence of motive for him perhaps to kill Paul, because this boat wreck case was becoming an anchor around his neck.
And that is the definition.
And then you could stop right there or get into the boat wreck
evidence having
accusation
any
more. But
tendency to
your
make the
emphasis of the
existence
word
any
any,
fact that is of consequence.
piggyback on what Justice
the
Few was saying,
determination of acts
I'm
and more
struggling with the
probable
logical connection that comes from the word
any
any.
fact
That means, seems to me you're just saying, whatever we say that makes sense, let's stick with it.
Well, by emphasizing that word, I don't think, and I'm not at all trying to assert that any sort of
I would emphasize
speculation
the
would be
consequence of the
sufficient.
determination
What I
of
am
the
saying
action.
is, again, the words logical connection. And I think that if it is a reasonable inference, as I just said, I'm not saying that the trial court should just entertain any speculation or any sort of fanciful thing that they come up with. I would, though, encourage y'all, though, to look,
Reasonable inferences, though, aren't what you want your prosecution doing. Your prosecution has to prove things beyond a reasonable doubt. Maybe if they linked up, like the defense said, a life insurance policy or evidence that they were about to spill this to the police and he was going to go to jail. I don't know. Something like that. But financially, I never saw the benefit of killing Maggie and Paul. And as an attorney, he should also know that if people sue him because he stole a bunch of money, then they can't go after Maggie's assets that are just in her name. But if she dies and he gets them, then those creditors can go after him. It actually makes the assets less protected. Or Paul's getting sued for the boats. His creditors don't attach to his parents' assets. I don't know.
Yeah, I never could find the connection.
It never made sense.
Mm-mm.
And we deal with assets and lawsuits a lot in our area of practice. So that was something that was floating around.
not only at the brief, but look at the filing that we did beforehand, and look at the PowerPoints and look at the closing.
Now, there were all kinds of issues with the receivership afterwards. And at one of the bankruptcy conferences, one of Mallory Beach's attorneys was there. They were talking about the receiverships and how complicated it was. And somebody raised their hand. They're like, why not just put them into an involuntary Chapter 7 and let the trustee divide it up? Brilliant solution, honestly.
Argument that, you know, this is not just a speculative motive. This all ties together. And I had a whole series of how I could go through all of that, I think there's about 10 factors of all things that were all coming to a head, all of that gathering storm that were coming ahead to that day. And that ultimately this, if you're looking at the validity of this, it actually worked. It actually worked, because when all of this happened, you know, Paul, who you just mentioned, had become that liability. Well, Maggie was too. Okay. Her name was on Edisto. Her name was on Moselle. And he was at the end of his rope and unable to move like he needed to move financially and out of options. He had burned through $792,000 in less than 2 months. And all of these.
I'm sorry, selling Moselle and Edisto aren't going to fix his multi-million-dollar problem. these aren't liquid assets. They have to be sold first. They're not going to pay off everything he owes. And basically, he's just liquidating them to buy more time and then left with nothing versus them not being able to attack Mackey's interest in them and having them protected. Just give them to the creditors instead of having them protected from Mackey's interest. It doesn't make sense, Creighton.
Things were coming to a head. But when this happened, everything changed. All of a sudden, he was the center of attention. All of a sudden, the sympathy factor kicked in. All the inquiries stopped, and the boat hearing stopped. The plaintiff in the boat hearing said, this has totally changed the balance of my case. And what did he set about doing? There was testimony that he wasn't overly concerned about buster security. He wasn't overly concerned about going after real colors. But you know what he did do? He fixed the glitch. He fixed the glitch so that his lawyer friend would send back or at least send an email saying all the money's here, and put that to bed. So if we're looking for that logical connection, whatever standard is applied, this is not speculative. I understand that it can be hard to accept that. Why would somebody do this? But that's precisely why this motive evidence was so probative and so important. And even though this is a unique case and a unique, maybe lifetime set of facts that will never be seen again, that's all the more reason why this needed to be admitted and for the jury to fully understand this unique individual from a unique background and a unique set of family circumstances and a unique lifestyle and a unique history that all was about to come unraveled. And that was more important to him than anything. And that when this action took place, not only did 2 of his liabilities go away, but all of those hounds at the gate went away as well. And if it wasn't for a check falling out of a file a few months later, it might have worked. It worked for a couple of months.
I got one more question to go back. What does it mean when something's not on his extraction?
It means that, the inference from that is that the user or someone deleted it. Thank you.
I want to ask a question about tool mark.
Sure. Justice Hugh has a question, sir.
Yeah, I want to flip over to talk about the tool mark testimony by Mr. Greer. There are a lot of cases around the country that have held that this idea of examining shell casings for tool marks is a valid method in trying to determine which guns a cartridge was cycled through. In fact, I'm not aware of any that go to the other direction. So
why not test this
abstractly, it seems to me like it's a valid theory. Maybe not. I'm just setting that aside for purposes of my question. But our cases have required not only that the theory be valid in the abstract, but that the theory be reliably applied. Justice Hill wrote about this in Warner at the Court of Appeals. We decided a case called Galloway recently where we stressed it. And really, I think if you go all the way back to Watson, that's what the court was talking about. As I read this record, there's nothing. I mean, literally zero about how Paul Greer used the method. He says he used it, but he didn't say I found 4 different individual markings. He didn't say here they are, here's where they were, nothing. And the thing that really troubles me about that is during the cross-examination by Mr. Griffin, I think this was in front of the jury. Mr. Griffin says, isn't your opinion in this case about the shell cartridges being fired from the same 300 blackout, isn't that based upon your presumption that each 300 blackout manufactured in the world makes unique tool marks when it cycles a bullet and ejects it? Now, that's a legit question. For a tool mark and firearms examiner, in my view of it, there's only one answer, and it only has one word, and the answer is yes. It's like DNA. If DNA is not different in every individual, then the fact that DNA, it would be of no use to anybody. Fingerprints are the same way. If fingerprints weren't unique to every individual, then we wouldn't have fingerprints. We also don't have tool mark analysis of cycled gun cartridges unless each gun makes a unique individual mark, right?
Yes, sir.
So when you don't tell the jury anything about how Greer applied the method, and Greer mistakenly fails to discuss the central theory of the whole method, how have you demonstrated to the judge that the theory was validly and reliably applied in this case to these facts?
Yes, sir. Well, I think as we look at the specifics of the testimony, and I would start with, I think with this issue and frankly, the TARP issue and the cell phone issue, that these are questions that go to weight, not admissibility. And I understand what
That
you're
ain't
saying.
what Judge Hill said in Warner or what this court said in Galloway.
Right.
That's not the law.
Right. Well, ultimately, I think that in this particular instance, if you look at the entirety of his testimony, he went through the acceptance generally of this for over 100 years. He went through the SLED procedures. He went through the acceptance and peer review in journals and the quality control procedures, the blind review. So while there may not have been a more specific explanation of that, the general discussion of the applicability and the reliability of the science was clearly in this record. And on top of that, I will also point to this that was in the record that shows that reliability. There's two things. Number one is that the examiner was able to distinguish between the cases around Maggie's body and the cases outside the gunroom door and the cases across the street and say that those were all cycled from the same weapon,
Okay.
but was able to distinguish those from matching it to the one blackout that was recovered. Okay. And so that distinguishing right there shows an inherent reliability to the science. And on top of that, then another blind examiner came up with that same conclusion. So that ability that was in the record to separate the wheat from the chaff answers the question, even if it wasn't explicitly answered, as Your Honor points out.
Thank you for your answer.
I'm glad you understood.
Mr. Marks, thank you so much. Appreciate your argument,
All
sir.
right. Thank you, Chief Justice and the court.
Ms. Barber, you going to handle reply?
All right. Now these are.
Mr. Chief Justice, may it please the court?
You-
I would-
I want to ask you, because it's fresh, you don't get 3 minutes uninterrupted. I was listening very carefully to all the arguments. Mr. Waters was trying to defend the admissibility of the expansive nature of the 404B.
Yeah.
And I thought he made a very compelling point,
Oh.
because one cannot fully understand, I think he used the word bowling point, without all of these interconnected parts. And so that's the logical connection that gives the judge the discretion to allow the fact finder to consider the evidence. So I'd like you to address that 404B issue, particularly that position argued by the state.
Yes, Your Honor. I thought that the strongest point, I really counter to that, was look at what was actually admitted. We had the victim impact testimony from the financial crimes, which I think the question's made clear have no connection. What did they connect to? Mr. Waters had a theme through his examination of all the witnesses. He asked every one of them, did you know the real Alec? Did you really know him? That was a question that was asked every single acquaintance. Did you really know him? You didn't really know him, did you?
Mystic character.
The theme there clearly was that you didn't really know. He's really capable of anything. He's a bad person. You don't know what he's capable of. And that's why that evidence that's why you had the mentally disabled, victim of a financial crime, which has nothing to do with the supposed motive of I need to conceal something because I might get caught, right? It has to do with, you don't really know me. I'm a really bad person. And because you don't really know me, you don't know what I'm capable of. So please speculate that I'm capable of murdering my wife and my child. That was the purpose of that evidence. We didn't have whatever it was, 12 days of financial crime testimony just to prove the fact that he stole a bunch of money and might possibly have had some fear that he might one day be caught for having stolen that money. And then the speculation is, well, he wanted a distraction, and we can talk about why this would, the logical leap to I'll just murder my family and be the center of attention and how that's somehow going to get scrutiny off of me, obviously doesn't make a lot of sense. And I think he, more than most people, is in a position to know, given his background, that putting himself at the middle of a high-profile murder investigation is not the best way to distract attention from his own affairs.
Good point.
So I believe that's why that's the logical disconnect. And then the real reason that it's submitted is this trial theme that you'll see in every single witness who had a personal acquaintance with him. Every single one asked, did you know the real Alex Murdaugh? And that's why that was admitted.
Thank you, sir.
If I could, I would like to speak a little bit to the cell phone questions that
oh my gosh, get off the
I
cell
believe
phone.
Respectfully, maybe the factual predicate behind some of the questions might have been a little off. By way of very quick background, the iPhone has a database that records with a timestamp every time the screen lights up, every time it goes off. Various events will cause the screen to come on and off. An incoming phone call turns it on. It stays on for a period of time. It turns off. Incoming text messages, other kinds of alerts. And then there's this rise to wake feature, which is slight movement of picking up the phone causes it to come on and off. Now, there's an entirely separate feature called an orientation change, which is it
What do you
moves a
think the
different way
orientation-
enough to rotate the
You
screen
just
we've all
wasted
seen
a
from
minute
portrait to
on this. It's
landscape.
probably not
And that only
relevant.
happens if the screen's already lit. The importance of all this is Maggie's phone screen was lit continuously from about 9:02 to almost 9:07 PM.
Which
So
means
it's
you're
lit
still
that whole
alive.
time. It did not just suddenly light up at 9:06 and 12 seconds. At 9:06 and 12 seconds, what happened was the final orientation change, which was a process that took 8 seconds and ended at 9:06 and 20 seconds. Right. And at that time, at that exact time, there was an incoming call from Alec Murdoch. Right. So it's rotating, someone's rotating while he's calling the phone. Her phone was lit up that whole first
He had
5-6 minutes because he was
Maybe
called her
he's
phone, I believe,
fumbling
3
her
times,
phone
texted
while
one
he
time.
calls her.
It stays on for a minute after. That's why it stayed on the whole time. So it could have, if the issue is with the screen
It
lit,
could have
it was
been
lit
Alec.
at
It doesn't
9:04,
necessarily have
9:05, 9:06.
your case.
So
Just move on.
if throwing it out of the moving car causes the screen to light up, it could have been thrown out at any of those times. But it goes off
Oh my gosh,
before
3 minutes into this.
9:08 and 20 seconds, which is when we now know, drove by the point where it was recovered. So the screen is off that whole time. It doesn't come on again until there's another call, 20 minutes later, right? So it's dark the whole time he passes it. So the issue is,
This is all directed at my questioning Mr. Griffin about the importance of the expert, of the testimony, the evidence.
yes, Your Honor, absolutely.
Your answer is that it's important if the murder occurred between 9:02 and 9:07. Why is it important if the murder occurred after 9:08?
Your Honor, it's not when the murder occurred, it's when after the murders, when a phone is thrown to the side of the road.
We mean after the
Right, but the
murders.
phone wouldn't have been thrown to the side of the road before the murder.
Correct. The point is that at the time
So are you
that we
admitting
know
that
for
the murders
certainty,
happened at
the
9:02?
defendant drove past where the phone was thrown, the screen never came on. There's a long period of time before that when the screen
Well,
was
I
on
mean,
continuously.
you make a great point. If all this occurred before 9:07, then my questions to Mr. Griffith were, as you pointed out, factually flawed.
Mhm.
But if it all occurred after 9:08, now you answer the question, because I think the validity of my question is now squarely on the table.
If your question is, could it have been thrown out after 9:08 PM? Then the answer would be that would be inconsistent with the screen not coming on. Yes. The point is the phone had to be thrown out before
Which
he
means
drove
the
past
murder
that spot.
happened before 9:08.
And that fact was not known until near the close of the
I
state's
just gotta
case.
help you.
Right, because somebody at General Motors was watching the trial, saw when the FBI agent testified on cross that they don't cooperate with murder investigations. Somebody took exception to that, and they produced accurate data. I mean, to pretty much every 3 seconds, not from his vehicle, but from a server General Motors keeps, far away, tracking his every movement, even though it was years earlier.
So at 9:08,
And so all of a sudden, we know exactly
leaving, and you're
where he
saying
is, and know
that at 9:07 the
with certainty
murder
it's to the
happened?
second when he drives past that spot, and we know that the phone is dark the whole
So
time.
she's
So the question becomes, is it possible to throw the
unvetted.
phone out at that moment without the light coming on? And as Mr. Griffin said, we don't know how it got there. Somebody could have stopped the car and gently put it out, but we know he didn't do that. So that's the central question. And the testimony from the defense was, here's the feature, everyone can see it. I'm not qualified to say whether throwing it from a car will cause it to do whatever. We had an accident reconstruction guy who was qualified to say that. But then the defense rebuttal expert, they bring in a chain of custody expert from the direct
They told
who
him
says,
to move
well,
on from this. I think you
threw it
should
around my
move on
office.
from
No one
this.
saw me do it, but I'm here to offer you what Mr. Waters
Now we
accurately
spent like
described as an
this
expert
entire
opinion,
reply
that
talking
if
about
it's a
this.
gentle motion, this is what it does. But if it's a violent motion, this is what it does. And this is why it's programmed to do and behave in that fashion. That's clearly expert testimony. It was well beyond his expertise. He was offered as somebody who knows how to use Celebrite to download the extractions that we've been talking about. And as to the preservation, it was immediate objections as soon as this came out. The motion was renewed the first time the jury left the room. The judge ruled, Judge Newman ruled for the reasons he gave in the record, which we assign error to. It was not an untimeliness ruling. So I don't believe that there's merit to the preservation argument there. The judge even said that the objection was preserved for the record.
Is there any dispute that Mr. Murdoch called 911 20 seconds after OnStar recorded that he arrived at the scene where the bodies were?
No, there's the timestamps that OnStar produced and the 911 timestamps are not in dispute. I would note that the nature, it's a rural area, and just because you first got there, it's dark. You don't necessarily immediately see someone the first second.
I don't think 20
OnStar
seconds
says that
is
you
a
pull
long
up,
time in a rural
and you've got to get out
area.
and look, and then his phone is connected to the Bluetooth.
Probably not well
What do you say
lit.
to the state's argument that that's not enough time for him to do what he said he did, which was go check on the bodies, which were 30 feet apart?
In 20 seconds, to look at two bodies that are 30 feet apart, I don't think that's impractical at all. I think I could, if you think about a pace is about 3 feet. If you're alarmed, you could take a pace in less than a second, right? That's not, you don't even have to break a run to do that.
Can you respond to Mr. Waters' comments or argument about the clerk of court?
Mm.
Absolutely, Your Honor. I think the most important point to point out with that is that there was absolutely no finding by Judge Toll that Juror Z was dishonest. That is not a finding.
She said she was ambivalent.
Your Honor, she said that only as to her response to the question forbidden by 606B about the influence this had on her deliberations in the deliberation room. She said she was ambivalent, whether it was that or pressure from other jurors during deliberations. There was no question of her credibility when she was recounting what Clerk Hill said to her before deliberations began. None. The only evidence presented at that hearing, the only evidence contradicting anything Juror Z said or the alternate said or that was proffered by the egg juror in the affidavit, the only evidence whatsoever was the testimony of Clerk of Court Becky Hill. It was not credible at the time, and it turns out that Judge Toll, was good at judging credibility because it has since come out that she perjured herself at that hearing when testifying about a different issue, but about her conduct at the trial. So she was the testimony of a perjurer at that hearing, admitted perjurer, is the only evidence contradicting the statements, the sworn statements from Juror Z, from the alternate juror, from the sworn affidavit of the egg juror. So our position would be that it is would be wholly unsupported by the record to credit that denial from Clerk Hill over all the other evidence in the record. That would, if that finding were made, which the state argues was implicitly made, certainly wasn't explicitly made, that would be an abuse of discretion. However, we argue that that wasn't implicitly made because Judge Toll didn't reach these sort of almost nitpicking, was this said versus that said. She found that in it, her word exactly was improper. Improper comments were made to the jury. She found that it was a deliberate attempt to influence the jury, that she had a book deal. That was all found. But it didn't matter whether it was this comment or that, because her decision was controlled by an error of law, which was essentially that the defense had the burden to show some sort of but-for causation to the verdict. It didn't matter because it didn't affect the verdict. Whatever was said was improper, but the verdict would have been the same no matter what. That's the written order. And that is the error of law, because the prejudice, which has to be shown, is the prejudice to the fair trial, which is that these things were said to the jurors, right? That's the bias, right? This was said to the juror. That's the bias. We've shown the prejudice when we've shown that it's been said to the juror, because now we don't have an impartial jury.
Verdict, but prejudice
There's no need to show
to the fair trial.
the effect of the bias on the verdict.
He says the comments were fleeting and innocuous. And Judge Toll said limited in subject and not overt as to opinion.
Yes, Your Honor, and maybe to address the question I was asked at the very beginning, is that a question of fact or law? What was said? That's a compound question. What was said is a question of fact. Characterizing it as an application of law to fact is a mixed question. To the extent you have to disaggregate it and say, well, what was said? Again, the only evidence in the record, right? Unless you were to accept the found to be not credible testimony of Clerk Hill, who's also perjured herself, the only evidence in the record is that those don't believe the defense was said. Don't be fooled by the defense. That's the evidence in the record. All right. So given that said, to characterize that as neutral as opinion is an abuse of discretion, and it is a misapplication of law to those facts. To find that wasn't said would also be an abuse of discretion, because it would be a finding wholly unsupported by the record.
Maybe one. I'm just going to remark that it's not fair to you and Mr. Waters that y'all had to talk about every issue, and these other two deadbeats over here only had to talk about half of them. But are you good to talk a little bit about some of the real nuances of the tool mark?
Absolutely.
Okay. You put in the pretrial hearing, or Mr. Griffin did, so the theory of tool mark is set forth in several documents that have been widely circulated and published by the AFT and so forth. But there have been criticisms of those. And one of the most striking ones is this idea that the conclusion, how they reach a conclusion, is circular. And that makes some sense, really. But my question to you is, wouldn't you say that those criticisms go more to the application of the theory than they do to the validity of the theory?
Yes, Your Honor. If I could, it's important I think the best way to look at it is to compare it to DNA evidence, because it's so striking, right? Everything in the universe is unique, right? The tool marks are all unique. The question is, do we have a process that can reliably distinguish, the cause of this mark to the exclusion of all others, right? That's the actual question. I did this process, and I can say, with some degree of certainty that, these two tool marks are made by the same weapon and not two different weapons.
To shorten it up, I'm suggesting that you just asked a really good question. Do we have a process to differentiate? And I'm suggesting that these criticisms that have been published, particularly this idea of the circular thing, would answer that question. Yes, we have a process, and it works. It's valid, but it has to be meticulously applied. Is that a fair way of interpreting those criticisms?
It's certainly fair. Where I was trying to go with that is, with DNA evidence, as the court knows from the many DNA cases that it's had recently, these differences are quantified, and you get a very 1 in 8 billion or whatever chance that these came from different people. We say it's a match, right? Here, you have this very circular and very subjective. What you have in the end is two marks that look really similar. and somebody eyeballs them and makes a subjective judgment call that these two look really similar. And our basis for that is circular because we say, well, I look at this part and that part, and it's like, well, how do you know that that means they're the same? Well, that's what we've always done. That's what I was trained to do, and it's very circular.
The theory says you have to find whether they match. And the next question is, well, how do you know that? And you said you have to find sufficient alignment. And,
Right.
and nobody ever comes down with a hard rule like you got to find 5 marks on the same cartridge that are identical to the 5 marks on this cartridge. Whereas with DNA, particularly with the ideas like touch DNA, you have the experts saying, I was able to identify 8 pairs of chromosomes and they match to what was at the crime scene or to what we found from the defendant, and that gives a 1 in 1 million chance that it is somebody else.
And to do anything like that with tool mark, you would have to quantify the similarity and differences of the tool marks.
And that's what I'm getting at is all of that goes to the application of the theory, I think, not to the abstract validity of the theory.
Absolutely. And there could be a day that with computers or AI that you can quantify and do something differently. But right now, having somebody eyeball it and say they look pretty similar to me, I think they're the same, that's not a reliable application of the theory. It's totally subjective. It's not quantified in any way. And it's certainly not something that could be subject to any sort of.
I wasn't trying to get you to concede that the theory is valid. I was really just trying to focus in on the importance of an explanation of how the theory is applied in an individual case. Thank you.
No further questions?
Hearing no other questions, Mr. Barber, thank you so much. And I
Thank you, Your
speak on behalf of the entire court. I want to commend excellent counsel on both sides.
That's
Thorough,
it.
detailed briefs, very helpful to the court and its staff. That is combined with arguments that reflected a commendable command of this lengthy and complex record,
Yeah.
together with applicable law. And it has all resulted in excellent arguments today. You've represented your respective positions professionally, and we all
I
on the
agree.
court commend counsel for both sides. We are adjourned.
All right. So we're going to have to check the opinions and see when we get a ruling on this. Those were good arguments.
They were very good arguments.
Oh my gosh. There could be a new trial.
There could be a new trial for sure.
I felt like the I felt like they were pulling for, I don't know. I felt like they were a lot harder on Creighton.
Yeah.
But all right, I was going to show, I have a video of my friend and I driving past Maggie Murdaugh's beach house in Edisto. It's not too far from my in-laws' beach house, but maybe we'll save that for when the opinion comes out. Oh man, what a great argument. Great questions from the judge. I think they needed to spend less time and on the cell phone thing, but so thorough. And there were arguments that they made for a new trial that weren't even addressed here, where they relied on their briefs. So that was excellent. That was excellent. Yeah, I just need to process it, but yeah, I said my thoughts during it, and it was good to hear the court echo some of those concerns. Wow, new trial. We will see. I wonder if they would even do it, or if they would just, I mean, he's spending essentially a life in prison with the financial crimes. He would be able to go to federal jail instead of state jail. Right now, he's serving his life sentence in state jail, so he gets to go to Club Fed. Not that it's like that much better, but yeah, it's federal. Federal has more money. What do you think? New trial? What are your hunches? Paralegal D.
I don't know. Paralegal D is tired, and I have a dog that's been bothering me the whole time. I think
there
it
might
could go
be a new
either way.
trial.
I think it could go either way, especially with the whole prejudice stuff of the I'm sorry, perjury with the court reporter, the things that she did.
I was always worried about that character evidence. That's the first thing I said to you.
Mm-hmm. Well, yeah, because even when me and you were talking about it a little while ago, the only
Right.
connection I saw with the financial evidence was character.
And that's impermissible.
Mm-hmm.
It's going to be a good opinion. Probably will be a long opinion, but when we get it, we'll be back with it. We'll make it into an episode instead of a live. All right, Channel Surfers, thanks for watching with us if you watched with us, and we will see you soon. Bye.
Bye.